continue this hearing session on infrastructure impacts. For those of you who haven't been attending over the last few days, my name is Scott Ferry. I'm an Assistant Chief Reporter in the Scottish Government's Planning and Environmental Appeals Division, and I've been appointed by Ministers to consider the notified application at Hermiston and report to them with recommendations. Before we go on, can I first ask that mobile phones are switched off or switched to silent? In terms of fire alarms, there are no drills due today, so if an alarm sounds, we should leave by the nearest staircase just to the left. As advised in the note of the pre-examination meeting, these proceedings are being webcast live and will be available for viewing later online in the DPEA's webcast library. So this hearing session, which commenced yesterday afternoon, we considered flooding impacts yesterday afternoon, and we're continuing on this morning to consider education infrastructure impacts. The hearing session will be conducted in accordance with the hearing session rules and will essentially be a structured discussion led by me. So before going any further, I'd just like to confirm who's participating today.
Morning, sir. Ewan MacLeod from Shepherd and Wedderburn, and to my right is Mr. Robin Holder of Holder Planning, representing the applicant.
Thanks for that, Mr. MacLeod. For the Council, Mr. Alexander.
Morning, sir. I'm Rory Alexander from Morton Fraser. I have alongside me to my left Crawford McGee, who is the Acting Head of Operational Support at the City of Edinburgh Council, and I also have Ian Tame, who is a School Estate Planning Officer at the Council.
Thanks for that. For West Craigs, Mr. Wilton.
Good morning, sir. Craig Wilton, Burness Paul for West Craigs, and to my left is Gary Mappin, also for West Craigs.
Thanks for that. We also have RBS with us this morning.
Yes, sir. Michael Gregg, DLA Piper for RBS. To my left is Rob Newton from GBA.
Thanks for that. There's one other participant, Mr. Houghton, who represents Ms. Harrison and Dr. Scott. We discussed flooding impacts with Mr. Houghton yesterday afternoon, and he hopes to join us later today to take part in subsequent discussions. So, before we move on to item 2 on the agenda, is everyone happy with the way that we'll proceed this morning?
Just
Mr.
one
Alexander.
small housekeeping point, if I may, sir. It's just been brought to my attention, one of the council documents, CEC4, it's described in our notes as draft supplementary guidance on developer contributions, and it also refers to a planning committee report dated 30th March 2017. I understand that the committee report itself wasn't included with that. I have hard copies here if that would assist you or any other parties.
So document 004 is the draft supplementary guidance, and what you're suggesting is that we should have the committee report that accompanied that?
Yes, that's what was referred to in our notes, but unfortunately the report itself wasn't included in the papers lodged.
Any comment on that, Mr. MacLeod?
No, sir. I've got a copy of that already, so I'm quite happy with that.
Okay, thanks. Do you have a hard copy for me? Great, thanks for that.
I've got an electronic copy, but if the reporter's got a hard copy, do you mind if we have one as well? Thank you.
Sorry, have you got an additional copy at all? Thank you.
Okay, any other points before we move on? Nope. Okay, so item 2 on the agenda is an item really arising from the fact that we've pushed consideration of transport-related impacts into a later session. We've been having updates through the week as to how things have been moving on between the Council and the applicant on the additional assessment or information that's being worked on. Is there an update on that today, Mr. Alexander?
Yes, I do have an update. We should have the additional modelling information within the next day or two. As soon as that's available, I'll be able to circulate that electronically with hard copies to follow.
Mr. MacLeod, how does the applicant envisage things moving on once that information's been made available by the Council?
I think the next step in that is for my traffic consultant to review what's been produced and provide some commentary on it. I don't know whether there will be further modelling that's required. I think it will depend on what the updated Jacobs document shows. I'm also conscious of what was discussed yesterday at the SASA session in connection with flooding of Gogar Station Road, and your request that that is something that's addressed at the reconvened transport hearing. I've not yet had a chance to discuss with the transport consultant how that would be done and whether we would need Mr. Stewart to come back and give evidence on that as well. So the short point is, at this stage, I'm afraid I just don't know how quickly we'll be able to provide you with updated documents if more are required. But we'll maybe just keep that under review as and when the Jacobs document becomes available, and obviously advise all parties as to what we think a likely timetable for production of any further information is likely.
It's likely then that once this additional information is made available to all of the parties, we'll then need updated, really fresh hearing statements on transport infrastructure, I think. I think we should roll transport-related conditions into that. And we're really, I think, looking at a rearranged hearing session on transport impacts no earlier than July, I would have thought. Does that sound right?
I think it does. At one stage, I think at the beginning of the inquiry session, I'd indicated that there was a vague hope that we might have been in a position to lodge everything by the end of this week, which might then give parties sufficient time in which to consider and respond and have a hearing session towards the end of June. I understand there are availability difficulties anyway for some of the principal parties. Having spoken to some of those parties informally out with the inquiry, I think that July is going to be difficult, and I think most of us are probably working on the assumption that, subject to your availability, sir, we might be looking at a reconvened hearing session sometime in August.
And that, well, it's hard to tell, but that might tie in with any need for an additional inquiry session on SASA impact, so we might potentially be looking at joining or having those sessions sequentially running one on from the other would seem an obvious thing to do if that works for the parties.
I'd been thinking exactly the same thing, because if Miss Wilson has to come back for a transport session, it would probably make sense to have the SASA session on the topics we discussed the other day first, and then move on to the hearing session on transport after that.
Okay, my availability in August at the minute is not bad. It's not brilliant, but not bad. I'm not thinking it would be impossible to do something in August if we've got the information that we need by then and the other parties are available, so we can just see how things go on with that additional information on both topics and keep in touch through the office on that.
Yeah, I appreciate that the new evidence is not yet available on either SASA or indeed for transport, but would it help if I gave an indication that I think we're looking at probably 2 to 3 days maximum to cover all of those issues, and perhaps just get a view from other parties in the room whether they think that's a reasonable estimate as well?
That's including SASA issues. SASA aren't here, so they can't give us an indication of whether they think that would be reasonable. Okay, but on the other issues, yeah, I don't see much benefit in going around the room on that. I think there's just too much uncertainty around that. But my feeling is that 2 to 3 days wouldn't be a million miles out to take both of those issues together. So we should be thinking along those lines. Okay, any other issues on that particular topic?
Just a couple
Mr.
of points. Thank you, sir. Just in terms of what documentation may be forthcoming from the applicants, as I understand that there would, from discussions between transport consultants, I'd understood it would be intended to be a revised Lunstig analysis for whatever junction mitigation proposal is being put forward. So I suppose
can I ask that you take the microphone a bit closer?
Apologies.
Struggling a bit
better.
to hear. That's better.
I was just saying, sir, I'd understood that there would be a revised Lunstig analysis would be forthcoming. So just to clarify whether that is correct.
Yes, that is my understanding.
The second point, sir, is just in relation to future procedure, as well as revised hearing statements. I think it likely, certainly from the RBS perspective, and that may be the same for other parties, that there may be additional documentation which we wish to lodge.
Yeah, my feeling is that would be unavoidable if fresh information is coming in, so we would almost be setting the clock back to zero again, I would think, on transport issues, so a run-in with documents and statements again.
Yes, sir. And I think the way that I'd envisaged this panning out was that there would probably be discussions between transport consultants on various issues over the next couple of weeks. There would probably be an understanding reached as to what evidence required to be lodged. And then you'll recall the EIA issue, which Mr. Gregg helpfully raised a few weeks ago, and the suggested approach in relation to that, where essentially what we would ask you to do at a point in the not too distant future is to issue a procedure notice requiring the production of certain information. We would probably give you a hint as to what that information was, and you would then issue the procedure notice. There would be a response to that, and that should hopefully address any concerns from any of the parties in the room regarding compliance with the EIA regulations.
I think we've indicated by email that would be our intention, or that in principle we felt that would be an appropriate way to proceed. That procedure notice would not only ask for additional information, but it would also set in train arrangements for the rearranged hearing session. And I think that's the way that I would intend to proceed. Perhaps complicated by the aim of running the SASA and the transport sessions sequentially, but I think there's probably a way around that. It may be that the procedure notice doesn't identify a definite date for the hearing session, but a range of dates or something like that. Okay, any other issues on that?
Sir, just 2 points. One is, if I could ask that West Craigs are included in those discussions between transport consultants, which I don't think has been the case to date, but if we can be involved in that, that would be helpful. And on the EIA point, I think, sir, it's really one for you and Scottish Government as to just how far the procedure notice can go in terms of addressing the failures in the process to date. West Craigs are not saying that they've suffered prejudice because of a failure to comply with the EIA regs, but I think the point that Mr. Gregg made before splits into two parts. One is information that has already been provided but wasn't properly notified, and new information. And if the intention is that the procedure notice is an attempt to remedy the first error, then I'm not sure that that's what the regulation is intended to do, but it's perhaps something for the applicants to pick up. As Mr. MacLeod said, they'll give you a hint as to what they'd like to see in the procedure notice.
Yep, I think we're all clear on that second point. On the first point, is there any reason why West Craigs couldn't be involved in those discussions?
I suppose the question comes back to if what we're talking about is discussions related to the detailed design of the RBS roundabout. As I've said in previous submissions, it's difficult to understand what locus West Craigs has in relation to that issue. That seems to me to be an issue that's between the applicants, RBS, and obviously the Council as Planning and Roads Authority.
Mr. Wilton.
I'm struggling to see what the prejudice would be in West Craigs being involved. What the previous exchanges of correspondence disclosed was, I think, a misunderstanding, perhaps on the applicant's part, as to the extent of West Craigs' land interests and how far those extended. There's also the point that this is about the road network, and so to try and deal with things in isolation, I think, is counterintuitive to that process. And finally, if the applicants are seeking to avail themselves of the foreshortened notification procedures that can be applied in EIA context, then you can't really have your cake and eat it. The whole point of it is that parties are able to participate in the process, and if you actively exclude a party from that, then I think that cuts across the operation of Regulation 24. As I said, I don't see any prejudice, and I wasn't anticipating the applicants having a difficulty with West Craigs being involved.
Okay. On the Regulation 24 issue, I think there's a distinction to be drawn between information being provided and made available to the parties, and no one's suggesting that information wouldn't be made available to you. Whether that then has to turn itself into some sort of imposition of a party in negotiations, I think that's a different thing, and out with the scope of Regulation 24. I think I can say no more on that. If it was likely to be useful, if it was likely to lead to a narrowing down of differences to be discussed at the hearing session, I would encourage the parties to talk to each other in the run-up to the hearing session. If that wasn't the case, if that wasn't necessary or unlikely to lead to a narrowing of differences, I'll hear all about that at the hearing session in due course.
Certainly. So the request was made with the intention of trying to facilitate matters.
Appreciate it. Okay. So that was item 2 on the agenda. Item 3, I had a question mark over SASA traffic impacts. That has been pushed down the line now, so that will be rolled into the transport session now, I would think. Yeah. Item 4 was flood risk, which was dealt with yesterday afternoon. I didn't note any comments on flood risk from the other parties who are now here but weren't yesterday afternoon. Can I just check that there's nothing that either West Craigs or RBS wish to say on the topic of flood risk?
No, sir.
Thanks for that. Mr. Wilton, you were observing, in fact, yesterday afternoon. Okay, so on to item 5, which is education infrastructure. I think this can be taken fairly shortly, although I may live to regret saying that. But I've got two questions, essentially. The first is that the proposals to mitigate the impact of the development on schools are set out in the agreed statement between the applicant and the council. That's a two-page statement that was submitted in advance of the hearing session. That statement appears to be predicated on the draft supplementary guidance currently with ministers. Are there risks to proceeding on this basis prior to adoption of the supplementary guidance? And what if it isn't adopted in its current form? What would the fallback position be? Could I hear first from the council on that?
Thanks, sir. I can perhaps hand you over to one of my colleagues, but in terms of opening statement on that, the council are quite clear that the sum sought for, I presume you're talking about secondary education in particular, the sums sought on the per unit basis are adequate in terms of what solution the council will come to on secondary education for that area. So in the event a new high school is certainly an option, an extension of one of the existing schools is an option, but the council are comfortable that whatever option is taken forward for the delivery of secondary education for that area will be sufficiently dealt with the sums sought, which have been captured in the agreed statement.
My understanding is that you've been proceeding on the assumption that a new high school, a new secondary school would be provided somewhere in West Edinburgh. That seems to be the council's current intention. I didn't catch again what the other alternatives would be if that weren't to proceed.
Fundamentally, the council has a duty to provide, a statutory duty to provide school places. We have in train a process that the action programme be updated on an annual basis as alongside our school roll projections. So there are many different options for providing those statutory places. At the moment, our preferred option is the new high school.
And presumably an alternative to that would be augmenting provision at existing secondary schools and using the sums that are brought in to do that.
Yes, that would probably be associated with a range of catchment reviews of those existing schools' catchment areas, which would require a statutory consultation.
But that nevertheless the council is happy that the sums set out in the agreed statement would be sufficient either way.
Yeah, I mean the council has a big infrastructure programme to deliver over the next 10 years. Some of that associated with the local development plan. There are there's a great awareness among elected members that the funding of that will need to be underwritten by the council, so all the contributions and the formulas for that have been well thought through.
Any of the other parties wish to add anything to that?
Thank you, sir. West Craig's concern on the issue of education, I think, can be sort of summarised as a concern as to the robustness of the council's assessment of the impacts of this development and then the efficacy of the measures that are suggested to deal with that. On the point that you've raised about secondary school, I think it's a fact that the action programme identifies a new secondary in West Edinburgh as the solution. The action programme doesn't identify a plan B for that in terms of other options. And in fact, other options were discounted by the Council between the adoption of the LDP and the publication of the new action programme. So the LDP did envisage extensions to existing schools to accommodate the LDP allocated sites. And it was only subsequent to that that the Council changed tack and promoted the secondary school. And I think so. You've probably already, from your question, you've probably already picked up on the uncertainty about that new high school, and I don't propose to go into that. From West Craig's perspective, the issue is the implications of this for their site as an allocated site. The catchment high school for the application site is the same catchment high school as for West Craigs for HSG 19. And I can't see any evidence of consideration by the Council as to what the implications of the grant of consent here would be to the delivery of HSG 19.
West Craig's concern relates to the secondary provision rather than primary provision, which is said to be provided directly within the development site.
At the time the hearing statements were lodged, there was limited information available on that. We do have some concerns as to the primary school position in terms of denominational, how that's been approached by the Council, and then the interim position on non-denominational, which are similar to the secondary school position. I think so. The agreed statement is silent on what the interim position would be for secondary education. It puts forward a position on primary, but it doesn't put forward a position on secondary. And there doesn't seem to be an interim position put forward for the application site on secondary. And as this site shares the catchment secondary with HSG 19, the concern, I think, is probably obvious.
Remind me what the catchment secondary is.
Craigmount High, sir.
Okay. I'll come back to the Council just directly, but does the applicant have anything that it wants to say on those issues?
Why don't we hear from the Council first to hear what they've got to say, and then
Okay.
we'll tell you.
I think that makes sense. I just was aware that I hadn't yet came to you on that.
That's fine.
Okay, back to the Council.
What is the question?
Well, the question was just really, as Mr. Welton has said, he has, or West Craigs have concerns that the catchment secondary for West Craigs allocated site and for the development site is the same, and that the Council's proposals for accommodating development from both sites don't appear to be clearly illustrated.
So I think the answer is the same answer I gave previously. Our current preference, as outlined in many supporting documents, is the provision of a new secondary school in West Edinburgh. We have a statutory duty to provide places for any child in the city, and we, if we have to expand schools to do that, if we have to do catchment reviews to achieve that, we've got a very good history of taking all of those forward in a successful manner.
Just going back again to the issue of the Council's aspiration to provide a new secondary school in West Edinburgh, West Craigs in its hearing statement had drawn attention to the fact that that isn't provided for in the LDP, and that there appears to be resistance on the part of the Scottish Government to providing such a school within the International Business Gateway. If the Council's aspiration for a new secondary wasn't able to be accommodated within the International Business Gateway, is there a fallback position on a site? Or if it isn't able to be accommodated within that area, is the fallback position this augmentation of existing schools that you spoke about earlier?
It could be either of those. There are options that we could look into for different sites, and as already explained, there are different options in terms of expansion of existing schools and catchment reviews associated with that.
And I think it's worth noting that irrespective of this particular application being consented or not, the position is that the Council's preferred option is that the area needs a new high school as opposed to the extension of current high schools.
So even in the event that permission was refused for this site, the Council's intention would be to continue to try to provide a new secondary within West Edinburgh?
Yes.
Okay.
So just very briefly on that point, the Council's change of tack between the LDP, where it was looking at extending existing schools, and looking at a new secondary, I agree is not dependent on this application, but it did take into account a significant increase in residential development on the International Business Gateway, which is another proposal that Scottish Government have expressed concern at. So the assumptions that have been built into the Council's desire for a new secondary in West Edinburgh are more complex, I think, than has been suggested.
It seems to me that the Council, with or without the site, has a very clear intention, either to, first of all, an aspiration to provide a secondary within West Edinburgh. Its fallback position is to find a site alternative to the International Business Gateway if that's not realistic for one reason or another. With a fallback position of augmenting secondary schools, the Council also draws my attention to its statutory obligation to provide for the schooling of pupils. You're not content that I take that at face value? Is there some reason that I should seriously doubt the Council's willingness and ability to make such provision?
Sir, I'm not challenging the Council's statutory obligations, which of course rest on it as Education Authority. If consent is granted and houses are built as Education Authority, they have to deal with it. West Craig's concern about the deliverability of a new secondary, I think, has been laid out, and the necessity of that as well. But it's as much an issue of timing and the implications of that for allocated sites, LDP allocated sites. There's nothing in the agreed statement or the Council's submissions as to when this would happen. The Council said at the LDP examination that one of the mechanisms available to it to control it or to help it manage its statutory obligations as Education Authority would be to impose suspensive conditions on planning permissions or use Section 75 agreements to control the level of development. It's perfectly, certainly the latter is quite common. There's nothing to that extent here. None of the conditions deal with this issue. Insofar as we have any detail on a Section 75 agreement, there's no suggestion of controls on development, and that is West Craig's key concern in terms of the assurances from the Council that in the absence of any controls on development of the application site, and given the high degree of uncertainty as to what the secondary solution might be, what we have is a commitment from the Council that they will deal with the children from this application site. And if they find themselves with a capacity issue because of that, then the allocated sites are put at risk, because the Council will then have to impose controls on those sites because it's not sought to put controls on this site.
And you have that, or West Craigs has that specific concern in regard to the phasing of its development might suffer due to a lack of capacity in the education infrastructure.
There's simply nothing. There's nothing there to allay that concern, sir. There's no cumulative assessment from the Council as to how they would manage this site with the LDPs. There's no commitment on timing, and there's no controls proposed on this site.
Council's response on that?
I'm not entirely sure what point is being made and what answers I can give beyond what I've already said. We've got experience in terms of LDP sites of working with developers to deliver and agree Section 75 agreements about the delivery of primary schools within their sites. It's clearly stated that the intention is to bring forward the secondary school by 2023. I don't know what more I can add to that. Yeah, so in terms of delivering a primary school, we really need to go through the statutory consultation process and deliver the school. We need about 3 years. And the intention for delivering the secondary school by 2023 is that we would need to do a statutory consultation in 2018 at the latest. So we're... Yeah.
And that statutory consultation is required regardless of whether the proposal is a new secondary school or a rezoning of catchment areas of existing secondaries, is it?
Yeah, you would have to have the details of your proposals in the statutory consultation. It's not unheard of to go forward with a statutory consultation with different options, as long as they're all detailed out.
Specifically, though, in regard to West Craig's concern that if somehow this site was approved and soaked up whatever provision there is at that time, or began to soak up that provision, so specifically in relation to the concern that that might mean that the Council at that stage in consenting the West Craig site would somehow try to slow that down, slow development of the West Craig site down to regulate the flow of pupils into the system. How would you respond to that concern?
I'm not the person that would be involved in setting planning conditions on limiting the number of houses that any developer could deliver. However, we have not once in recent history in a planning consultation response suggested that a development should not go ahead because we cannot provide the education infrastructure, or that any limits should be put on the number of houses developed at certain times because of education infrastructure. The Council at a corporate level has developed the action programme. It has an oversight group involving the Chief Executive and all the directors that look out over that, they oversee that action programme, and we have a corporate desire to support the growth of the city.
I mean, that in my experience would be quite an unusual position, my experience of other education, and I'm not doubting at all what you're saying, but just to put West Craig's concerns into perspective, it would be quite common for other education authorities to object to the development of housing sites, or to try to ensure that they're phased in such a way that the education capacity can deal with pupils from those sites. So just so I'm clear, you're saying that that is not Edinburgh City Council's approach?
No,
And you can demonstrate that through track record.
Edinburgh City Council, unlike many other areas of Scotland, has had an issue with rising roles through the primary schools, and the last administration was very clear that we would build where we had to, or do catchment reviews where we had to deal with that. And the approach being taken in terms of the local development plan and infrastructure to provide that is that that's the case, and that's why the detailed action programme has been prepared.
Okay, thanks for that. I think I've heard enough on that. To be honest, there's not going to be a meeting of minds, but I think I've gathered the information that I need to have on that. Is there anything that the applicant would like to say finally on that issue?
No, sir. Thank you.
Okay, so are there any other issues on the topic of education infrastructure before we move on?
Sir, it comes to the sort of the same point ultimately in terms of denominational primary and non-denominational primary, and I'll just take this short, and 'cause I suspect the answer, given that Mr. McGee's not can't speak to planning conditions and such matters. The position in the agreed statement on denominational primary is that an assumption has been made that given the travel distances to the denominational primary school, the existing denominational primary school, parents, children will choose to go to the on-site primary school. And I just, one point of clarification was that the emphasis is on the word choice there, that's not something the Council's Education Authority could compel them to do, is my understanding of it. And the Council could tell me if I'm wrong in that. The second point was simply to highlight that when children and families provided their consultation response to this application originally, and this is in the report to committee, I won't dig it out, but it's one version of it, the number is M26, which is the report to committee. Children and families consultation response was that 51 denominational pupils, primary school pupils, would be generated by the development. My maths on the applicant's amended schemes, 700 flats, remainder houses, is that we're down to 33, I think, denominational children. But in their original response, children and families assumed that all those children would go to a denominational school, and they're now assuming that none of them will. And the significance of that is that if you assume that they go to the denominational primary, which I understand is St Cuthbert's, it was identified that there was a need for new infrastructure. And a contribution of 700,000 was sought, or thereby was sought for that. I suppose the 2 points on West Craigs and that are, one, the council seems to have completely changed its assumptions on what denominational families will do, and two, if they're wrong in that assumption, what's the response to it? Because again, there's nothing in the agreed statement or elsewhere as to making additional education provision, denominational education provision, sorry. And I'd also flag that there is nothing proposed for St Cuthbert's Primary in the action programme as things stand.
Okay, could we have the council's comments on that?
I'm going to try and not repeat myself, but we have a statutory duty to provide places. Our assessment for this current hearing has been updated. We've taken the view that the most efficient response is to provide the school. We have evidence across the city. Queensferry is a good example where children choose in large percentages to go to the non-denominational school.
What sort of large percentages? Presumably it wouldn't be 100%.
No, not necessarily, because if some of the denominational, if some children choose to go to the denominational school from this new development, then the council has a statutory duty to provide those places at the high school, at the
denominational school.
Yeah. So I'm not aware. I've not obviously got the report that's been discussed in front of us, but what we have done is a full review of our projection methodology over last summer, and published our methodology and our projections in December, and we've got a commitment now to do that every year.
I don't think you're going to make more headway on that, Mr. Welton, to be honest.
No, I appreciate that, sir. I just wanted to I suppose, make the point that Mr. McGee is understandably putting across a position for the Council as Education Authority as to what the Council's obligations are as Education Authority. And as I understand it, he's saying that if these children arrive, he has to deal with it. He has a statutory duty to deal with it. That's not the same, though, as the planning position in terms of infrastructure being available or being provided at the appropriate time, which of course is the policy text. And that's not, we haven't heard from the Council to that extent, I would suggest.
I'm not convinced on that. If I'm understanding the Council's stance on this, the Council's position is that it thinks there are realistic proposals in place to meet those, to provide for education for pupils arising from that site. But if it's Plan A, if you like, and you talked about a Plan B, but if it's Plan A wasn't to proceed, it would nonetheless seek to provide for those pupils one way or another. And if the Council as Education Authority is telling the Council as Planning Authority that it can provide for those pupils, why would the Council as Planning Authority seek to regulate the flow of pupils from development sites?
Because, sir, it comes to the point of the cumulative impacts and the priority that's given to allocated sites. So, whilst the Council may be able to say, as Education Authority, it thinks it can deal with this site, and I think West Creek's position is that its Plan A is doubtful, its Plan B is very general, and it doesn't have a plan in terms of primary school denominational if its assumptions are wrong, because there's nothing in the action programme on that. But it's a question of the implications for other sites, that whilst the Council may be able to accommodate the application site, it's not clear that they can do that without prejudice to the delivery of the allocated sites, and that's the comfort that West Craigs have been looking for, that if this site is granted planning permission on the basis of the education provision that's being suggested, that it wouldn't prejudice the delivery of the West Craig site, which is presumably something Mr. McGee can confirm.
Can confirm what, sorry?
The delivery of the application site and the education provision for that would not prejudice the delivery of the West Craig site as an allocated site in the LDP.
I've noted the Council as saying that that wouldn't be its approach. Is that right? That it has a track record of not taking that approach? Yeah. Okay, I think I've heard enough on this issue. Okay, are there any other matters on the issue of infrastructure that we need to cover before moving on to the next hearing session? No? Okay, so that's our infrastructure hearing session completed. We're moving on now to consider housing land supply and the development plan. Are parties ready to move on, or would a 10-minute break be useful? Okay, let's have a 10-ish minute break and start again at 10:35. Back, everyone. I hope that was sufficient time to rearrange participants and so on. I won't go through the usual preliminaries. I think mostly everyone was here at the earlier hearing session, but for those that weren't, I'm Scott Ferry, an Assistant Chief Reporter appointed by Ministers to report to them on this application. Can any new arrivals switch their mobile phones off or onto silent, please? So, before working our way through the issues on the agenda, can I just take a note of those parties that are participating in this session? Mr MacLeod.
Thank you, sir. Again, it's myself, Ewan MacLeod, Shepherd and Wedderburn, and Mr Robin Holder of Holder Planning.
Thanks for that. And for the Council?
For the Council, it's myself, Nicola Woodward from Lichfields, and Rory again for Morton Fraser.
Thanks for that. Mr Welton.
Morning, it's Craig Welton, Berners Paul, Gary Mappin for West Craigs Limited.
And for RBS?
Michael Gregg for DLA Piper and Rob Newton for GVA.
Now, my understanding, Mr Gregg, is that RBS doesn't have much or in fact, anything, I think, to say on the housing land supply, so I won't come to you and ask you to contribute, but if there's anything that you wish to say, just indicate to me and I'll come to you in due course.
Thank you, sir.
Okay, so moving on to item 2 on the agenda, I'd like to discuss the parties' views on whether or not there is currently a 5-year effective housing land supply in Edinburgh. For the applicant, it's argued that there is currently a shortfall in that supply. It's contended that if the Council's Housing Land Audit 2016 is taken as read, the 5-year effective supply is 11,970 units against a housing supply target of 13,620 units. For the Council, it's contended in paragraph 2.24 of its hearing statement that there is currently sufficient land to deliver identified housing needs, including providing for the backlog. However, at paragraph 2.27 of the statement, it's contended that the Council's approach does show a delivery shortfall and that the application site would contribute to meeting this shortfall. Now, I'm a little confused that there seems to me to be some tension between the statements at paras 2.24 and paragraph 2.27. Can the Council assist me with that?
I can do my best. The Council have, through a number of audits, been grappling with the issue of housing delivery through the recessionary period, and obviously with the lack of finance, etc., all sorts of factors outside of the Council's control. Housing delivery rates have fallen short of what would be expected. So in the latest 2016 housing land audit, the Council have considered both the housing land that is available and unconstrained, according to the tests of the PAN, and also then the delivery programme separately. And this is where the difference in numbers perhaps manifests itself. Now, the Council's position is that there is enough land identified within the housing land audit to meet the housing land requirement as set by the SDP, and that therefore they have an effective housing land supply. And that's based on the number of sites available and the number of unconstrained sites available as tested against the accepted tests in the PAN. However, the Council have also gone on to consider the delivery programme and what the outputs might be from that effective land. And that's where the shortfall occurs.
Could I ask you just to slow down a little bit?
Certainly, sir.
I know we're recording this, but I'm trying to make notes too, so just go back to your however.
My however. So there is, in the Council's opinion, a stock of land that is effective and effective against the tests. However, the delivery programming is currently showing a shortfall as set out in those figures.
Due to what factors?
It's the Council's opinion that those factors are beyond the control of planning, that the planning tests have all been made. They might be market constraints, availability of finance. It's not necessarily clear. It could be a whole range of different factors, and it will be different factors on different sites. I think it's fair to say that housing delivery rates have been increasing in Edinburgh in the recent years, and that the Housing Land Audit and Delivery Programme notes that these rates are getting back towards what they perhaps were pre-recession. So there is some confidence that that the housing delivery is on an upward trajectory, which of course is a good thing.
Okay. I think we'll come back to that, but I'm going to try and keep my questions in the order that they're in, so I don't get hopelessly confused. Any points from others on that? No? From the applicant's point of view?
Really just a short response at this stage. And it's the fundamental point, which I think is that the Council are drawing what we consider to be a false distinction between delivery and effectiveness, which, as far as I'm concerned, I think the relevant PAN tells us are one and the same thing. Now, I don't need to perhaps go to the references in the PAN, you have those brought before you, but the PAN very clearly discusses programming and completions as a factor in determining effectiveness.
Sorry, that last sentence again.
Programming and completions are a fundamental part of the process of establishing effectiveness. And essentially, the Council's approach to effectiveness is to put to one side, ignore the delivery timescales that are agreed through the housing land audit.
Thanks for that. So, Council officers concluded in the committee report on this proposal that there was a 5-year effective supply in place, which would be consistent with what you've just said. Is it possible to discern the view of members on that issue in deciding to support the application proposal? Is the Council's apparent position that there is an effective supply in place the view of members? And if so, is it possible to know why members nonetheless decided to support the proposal?
It's never possible to get inside the head of members and know what each of them are individually thinking, and I wouldn't want to represent their views here today. However, the Housing Land Audit has been through committee, and it was, and the methodology was discussed at committee, and the recommendations of that committee report were approved by the members of the committee. So the housing land audits are considered through committee, and that's one process perhaps, but it was the same committee. It was the same committee that considered it as would consider the planning application.
Chronologically, I'm assuming that came after the Council's consideration of this proposal.
The Council's consideration of the planning application came earlier in the year, and the Housing Land Audit 2016 wasn't taken to committee until October. So the Housing Land Audit under which the committee were considering it was not the one that had been. The Housing Land Audit that was being committed at the time of the application was not the 2016 audit. It was 2015 audit, most of the time. Yeah, it was the 2015 audit at the time that the planning application was considered. The 2016 audit was later considered by committee in that same year.
What had the 2015 audit concluded in terms of the effective land supply?
The 2015 audit concluded that there was a shortfall.
Okay. So the position has changed between the 2015 and the 2016 audit?
That is correct.
Okay.
It's probably worth adding that at the time of considering the 2015 audit, the Council raised the issue of the continuing difficulties with the stock of land that they had and the ability to demonstrate that it was effective, and other methods or other ways of considering this were looked at the time.
Okay, thanks for that.
So just picking up on that point, it might be just worth looking at what the Council's position, or the Council officer's position, I should say, was at the time that the application was originally considered. And I think if you go to document M30, which is the report of 16th May to the Development Management Subcommittee.
Yep.
And you'll see it's pages 14 and 15 that deal with the 2015 audit and what's said about that then.
Okay.
Now, just in summary, and perhaps Ms. Woodward can confirm her understanding of this. As I understand it, at that point in time, the Council was taking the approach that or Council officers were taking the approach that rather than looking at the agreed programmed completions of housing sites, the appropriate thing to do was to look at what was described as the theoretical maximum completions. And that, well, there were a number of issues with that which I probably don't need to get into, but suffice to say that council officers have consistently taken an approach over the last 5 years or more that there is an effective land supply in Edinburgh.
Notwithstanding the conclusions of the 2015 audit?
Correct, yeah. So they have concluded that there is an effective 5-year land supply. And various arguments have been put forward as to why that is. Now, the council officers, various approaches to date, have been rejected by, I think, every Scottish Minister's appeal reporter who has considered them.
Including the examination reporters?
Yes, sir. And so far as I'm aware, every appeal that's been considered in the Edinburgh area in the last 3 years at least has concluded that there is a substantial shortfall in the 5-year land supply.
That was my understanding, and you know, I've seen that in the hearing statements, and it sort of takes me back to my original question, and I appreciate I might not get an answer to this, but in the context that officers at least were consistently concluding that there was an effective 5-year supply, is it possible to know whether members agreed with that conclusion, and if so, why they nonetheless supported this proposal? If you can't answer that, just say.
Yeah, we're obviously wanting to be as helpful as possible, sir. But I think, as we discussed at the pre-examination meeting, it's difficult to reflect on the decision made without going back to councillors, given it's a full council decision. So my understanding of our role today is to give you the current position of the City of Edinburgh Council in relation to housing land supply, and hopefully during this session, along with our hearing statement, we can set that out to you.
Okay, thanks for that. And my next question for the Council really was around the topic that Mr MacLeod has really just introduced, you know, with reference to appeal decisions and the conclusions of the reporters in the LDP examination. I'm assuming that the Council is just agreeing to disagree on that the Council's position is that although technically there isn't an effective 5-year supply, there is this nuanced position that there is sufficient land in the supply.
Yes, sir, that's the Council's position, that there is enough land to meet the requirements.
Okay, thanks for that. So the applicant's calculation of housing land supply in its hearing statement is based or is said to be based on taking the 2016 audit figures as read, I think is the phrase that's used in the applicant's hearing statement. To me that suggested almost, well, it posed the question when you say taking those figures as read, do you agree with those figures, or you might not fully agree with them, but you think they're a reasonable basis to work on?
I've usually worked on the basis that the agreed land audit is the agreed land audit, and it's a snapshot at a particular time. I have concerns, and I've had concerns over many years, and in fact I did a piece of research for the Scottish Government on the content of audits and the programming contained therein, and that research raised a number of question marks as to the tendencies for housing land audits to overestimate in their programming the delivery of housing, which comes really from two main sources, I suppose. One is that those advising the council, such as house builders, on their programmes tend to have over-optimistic impressions of how quickly sites will deliver, quite often because they have internal targets of their own to achieve. And related to that, a lack of questioning sometimes of councils of those figures themselves. And it's quite old research now. It dates back to about 2009, 2010, and this was commissioned by the Scottish Government. It concluded that on average, and it is an average figure across Scotland, by looking at actual delivery over a 5-year period compared to what housing land audits had said would be delivered over that 5-year period, it was an average of a 30% overestimate. And I don't see much change in the audit process since that research was written. So I always look at audits with a little bit of question in terms of whether they will actually deliver what they say. But in fairness, it is what the Scottish Government and other parties rely upon to firstly establish the base supply of a development plan, which is crucial, and then to calculate the 5-year effective land supply. We'll see what the next audit says, but I take the view that it is the current audit and it is the best source of information that we have.
Okay. And just so I can be clear, is the 2016 audit agreed? I know you've said it's been through committee and so on. Is it agreed with house builders?
It's been agreed with Homes for Scotland.
Okay.
I think there's one disputed site.
And is that a significant site?
I'm not very familiar with the site, but it's a site I believe is controlled by Forth Ports in the Leith area.
Okay. I'm thinking it's significant in terms of numbers and the supply. I was about
to go on to that. I think it has a programming within. We'd have to look at the audit, but it's in the order of 150 to 200 homes. Okay. In the 5-year programming period. It extends significantly beyond that.
Does that sound right to the council?
I believe it's the Western Harbour site, which is a Forth Properties Limited site. But in the audit, there isn't expected delivery to beyond this first 5-year period.
No expected delivery in the first 5-year period?
No.
Okay.
So my apologies for that.
Okay, thanks for that. One final question on this topic, really, and it's going back to the Council's different approach, or this nuanced approach that it seems to have adopted of late. We've talked about that approach not having been supported in appeal decisions or by the reporters in the examination of the LDP. Does this different or nuanced approach benefit from any wider policy or guidance support that the Council can point me to?
I think, sir, it's the interpretation of the guidance that exists. There was a draft policy guidance came from Scottish Government which changed slightly the emphasis of the assessment of whether or not land was effective. And within that context, this approach is much more favourable, I would say. But of course, that has never been finalised, although it was out to consultation more than a year ago. And it was within the context, perhaps, of that the 16 audit was prepared.
Okay, within the context, did it follow the approach set out in that draft guidance, as far as you're aware?
Well, the draft guidance removed issues such as marketability from the tests. I can't say explicitly that it did, but it was within that context that the audit was prepared. And certainly the Council have been in discussion with Scottish Government and others and other local authorities in terms of the approach that they have taken through the 16 audit, and there's ongoing discussions on whether or not that's an appropriate approach going forward if the guidance was indeed to be updated and changed.
Are there any documents before me that would illustrate those discussions or any conclusions?
No, there's no documents that we've presented that particularly minute those discussions.
Sir, just one or two actually comments very briefly on the draft guidance. You may be aware from other sources, but the guidance was roundly criticised by the house building industry, and one of the major sources of criticism, or main sources, was that it didn't deal at all with how you calculate a 5-year land supply and didn't address the question of pre-existing shortfalls. The second very brief point to note is my understanding is that the guidance has been shelved for the time being. Pending completion of the planning reform agenda, which is ongoing at the moment. And I think that's specifically mentioned in the consultation paper, and I can provide you with an extract of that if it's something that you feel that you need to see.
No, that's helpful. Okay, thanks for that. Any other contributions on the question of the housing land supply? No. Okay. You were right yesterday afternoon then. Okay, so moving on to item 3 on the agenda, consideration of the proposal against the policies of CES plan. And there's a degree of overlap, obviously, from what we've just been discussing, but we'll try to minimise that. So on CES plan, the applicant's view is that there is a housing land shortfall and that policy 7 of CES plan is therefore engaged. For reasons discussed at the PEM, Council offers no evidence currently on any development plan policy. Just on that point generally, I'm not anticipating that the Council will contribute to discussions from now onwards. Is that right, Mr Alexander?
For this session, that's correct, yes, sir.
So you're free to stay and observe, but I won't be calling on you here. Other than on policy 7, I'm clear on the parties' views on the other policies of CES plan, so policies relating to transport and so on. I'm clear that those will just apply or not apply depending on my conclusions on access and so on. So it's really policy 7 that I want to discuss today.
Sorry, I'm sorry to interrupt, but I just had two minor points. Well, 2 points. You can decide how minor they are in due course. But Mr Welton raised yesterday the Richborough Estates case, and I have got a copy for you, although I'm afraid I don't have any other hard copies for anyone else. So if you want to have that available to you, I can give you a copy just now. It may come up in discussions, and as I said, I think it will probably be a matter of submission in due course as to what it means. I'm looking forward to those explanations, as I'm sure you are. The second point, and I have an apology for Mr Welton because he had raised last week the issue of land ownership and the poultry farm in particular, and he had asked for an update on that, and I do actually have an update in the form of a letter. Now, it has literally just occurred to me that I've not mentioned that to him. I don't particularly want to give it to you until he has seen it and had an opportunity to consider it, and I wonder, I don't know where we are time-wise, but if I maybe just flag that's, if we get on to the question of ownership as part of effectiveness, might it be possible just to push that into the afternoon, and I can then give him this and give him an opportunity to think about what he wants to do about it?
I think that makes sense if you're happy with that, Mr Wilton. Yeah, perfect. Okay. Are you lodging the Rossborough Estates?
I can do, yes,
now?
Sir, which would be, I think, document M145.
Perfect. Others happy with that?
Yes, sir. I'd raised it. Can't really take an issue with that. The letter from the poultry farm, if there's a copy available now and then, that'd be helpful. Thank you.
Great. Thanks. Okay, thanks for that, Mr MacLeod. Could I ask that be lodged electronically with the office too, just so that they can keep the record up to date? Okay, so on CES plan policy 7, clearly if I conclude that a 5-year effective supply is in place, I would be concluding that policy 7 isn't engaged and vice versa. So I'd like to go through the 3 criteria set out in policy 7, just taking the parties' views on each in turn, if that's possible. The most efficient way to do this, and I think it will essentially be West Craigs and the applicant participating in this discussion. RBS, feel free to interject if you feel the need.
Sir, I think the only thing we may have something to say on is C,
okay,
but not A or B.
Catch my attention when we get there. The easiest way might be to do it is to take West Craigs first and then let the applicant respond, rather than the other way around.
Absolutely, sir.
Okay, so over to you, Mr. Welton, on criterion A of Policy 7, which is that the development will be in keeping with the character of the settlement and the local area.
Sir, I think from West Craig's perspective, our case on this is as set out in the hearing statement, in that we've hopefully drawn your attention to the conclusions that the Council's professional planning officers arrived at on the site, and also the examination reporter who had the benefit of a site visit. I'm not sure there's much more we can add to what's already in there. Mr. Mappin's got anything to, I'm very happy for it to be taken
Okay.
as read,
Perfect.
if that's acceptable.
Okay. Clearly give the applicant a chance either to rebut or to say happy for me to take as read what's in your hearing statement and clearly in your other papers on that.
Yeah. Well, clearly you have our hearing statement. Criterion A, development will be in keeping with the character of the settlement and local area. Clearly we've lodged a lot of documentation to demonstrate that point, and I'm not going to go through that now, otherwise we get into quite a lot of significant site-specific detail. I think probably in response to the hearing statement by West Craigs, they clearly refer to the planning officer's view of Edinburgh Council while considering the planning application, and we've provided you with significant commentary on that, and I don't think that I'll attempt to go through that now. The hearing statement by West Craigs looks at the examination report, the LDP examination report, and my view on that was that there was a quite selective interpretation of that, and don't
in terms of West Craig's interpretation of the examination report.
Certainly quite a selective taking of comments within that report.
Okay.
Perhaps in relation to Part A, and I can give for example, they say that the reporter concluded that there was and I'm paraphrasing, maybe the exact words are important, but a significant adverse impact in respect of views to the Pentlands from a particular viewpoint. And I think what that obscured was the examination reporter's overall view of the site, which is very clearly set out. There's quite a long section in the examination reports, 4 or 5 or 6 pages long, where all the issues are quite carefully balanced, I think, by the reporter. On landscape matters, which is what I'm considering here, I think the reporter concluded overall that it would have an acceptable impact, and that it would not, if you read that section as a whole, that it would not have an adverse impact on either the settlement or the local area. So we can go to specific tracts from that text, but you can read that whole section for yourself. And I'm going by recollection here, so we may want to go there, but I don't think the conclusion section raises any issue of harmful landscape impact. There is a specific mention within the text of the local view that would be affected. And I suppose the point I want to make, that a local view being impacted upon, and the word is impact rather than adverse impact, I think, but is different than the test in Policy A or 7A, which is that it be in keeping with the character and settlement and local area.
Okay. Mr. Welton.
Well, sir, the examination reporter obviously would have had regard to Policy 12 of CES Plan when looking at
Greenbelt objectives and ultimately concluded that the site shouldn't be allocated. In terms of impacts, I think the applicant's own landscape impact assessment concluded that there would be a degree of moderate adverse, I think they say, but significant in EIA terms, impacts from the development. I think we do acknowledge that this is a subjective issue, and in that we acknowledge that the examination reporter was not perhaps as critical as the council's planning officers were, but there is consistency, there's ultimate consistency in their approach in terms of their conclusions on what should be done with the site.
I think to say that the examination report's conclusions were not as critical as the council's criticism is not a fair reflection on that report. I thought that the examination reporters were very clear that it would certainly have no impact on the settlement and the character of the settlement, and it was very restricted to the one issue that I referred to earlier.
It might be worth taking us to that document.
You can find it in various places, I think, sir, but CEC 9 is one place, and it's page 499 in the examination report. I don't know whether the PDF follows the same numbering or not, probably not quite.
Okay, I've found that.
So page 499.
And there's a section overall conclusion east of Milburn Tower.
That's the one, yeah.
Okay.
And the specific paragraph that Mr. Holder's referring to is paragraph 53. And just for those who don't have it, the relevant sections are: a new greenbelt boundary could be established, recognising the potential for future growth. I accept that local landscape impacts could be sufficiently addressed by a layout and landscaping framework which maintains view corridors through the site and a landscape buffer along the road corridors. In addition, my conclusion above is that it would be acceptable, though not preferable, to establish an alternative greenbelt boundary following the deciduous tree belt along the western edge boundary to the east of Milburn Tower. The boundary could be managed and enhanced as a principle of any development of the site. So in essence, that's what the reporter had to say about impact on the greenbelt. And in my submission, on any fair reading, he was not expressing, in fact, she, I think, was not expressing any concerns about the impact the site in question would have on Edinburgh's greenbelt.
Sorry,
there was one last point just to get in before Mr. Welton comes back, and that is that, as Mr. Holder has said, there is a substantial amount of landscape and visual analysis, design analysis as well, presented to you by the applicants. West Craigs have presented no evidence to counter that, and simply rely on comments made in the Council's report, which, as Mr. Holder says, were responded to extensively prior to the committee that decided to grant planning permission for this development.
Okay. Mr. Welton.
A number of points raised there, sir. If I could go back to the Greenbelt point and the examination report, I've got the hard copy, but if I could ask you to turn the page or go to page 500, paragraph 54, where the reporter says in the final sentence of that paragraph, I consider that the extent of existing constraints to future development are significant and sufficiently uncertain at this stage as to caution against weakening this long-established greenbelt boundary. So there is slightly more to it, I would suggest. In terms of the position that West Craigs put forward, absolutely West Craigs has not undertaken a landscape and visual impact assessment of the application site. It's never claimed to be relying on anything of that sort. We've identified the conclusions of the Council's planning officers and conclusions of the examination report. In terms of the Council's support for the scheme, which the applicants rely on quite significantly in their submissions in terms of impacts, which I think are applicable to CES Plan Policy 7A, but they're because it's replicated throughout. I think what I would highlight to that is that when the Council were considering this application, and as their statement of case confirmed, they were approaching this as an either-or to identified sites. This was not an additional release from the Green Belt. This was an alternative release from the Green Belt, and that's the basis on which they approved it. And it might be helpful just to confirm that position, perhaps. If you have, if document, again, there's various versions of this, but document M26, which is the report to committee as annotated against by the applicants. That's page 14 of 99. It's the last paragraph, if you've got it, sir.
Okay, I have it. Do you have that, Mr. McLeod? Okay.
M26, yeah, page 14. It's 14 hard copy, 14 electronic. The reason for identifying that, sir, is simply that the text in red is the text from the applicants, and that confirms that this is in response to the ongoing LDP process as it was at the time. But the applicants say the granting of planning permission for this application is likely to lead to the capital coalition motion being realised. This is because the LDP examination reporter will be obliged to allocate the site if granted permission and would need to remove other sites from the LDP to accommodate that. And in their statement of case, the Council do confirm that the reasons for approving the application were the coalition motion. So when considering or placing reliance on the Council's conclusions to resolve to grant permission, I'd simply urge caution on that, sir, because what the members were, what was being put to them and what they were intending was that this site would come forward instead of other Greenbelt sites, and it was an additional site.
I appreciate that. Although ultimately that wasn't borne out in the examination, well, for a whole number of reasons, but even if the reporters had concluded that this site was acceptable for one reason or another, it would have been additional rather than an either or, given their overall conclusions on the land supply. Is that right? The ultimate conclusion was that they would have allocated more if they'd been able to.
Yes, I think there's a number of options available to them, and one of them would have been in response to the shortfall that they identified to allocate this site or recommend modification of the plan to allocate this site. They didn't do that, obviously. I think it would have been open to them to modify the plan to allocate this site and delete other sites if they'd felt that was the appropriate thing to do. I think that would have been an option available to them, and again, they didn't do that. But in terms of where we are now and the process we have here, clearly those sites are allocated. Nothing about this application process will do anything about that. And so this is, what is clear is that this will be an additional Greenbelt release.
but in a position of the examination reporters having found a shortfall.
Absolutely, sir. Yes.
Mr. MacLeod.
We obviously strayed into some slightly different territory to policy 7A there, but just coming back to that point, as Mr. Welton quite rightly said, paragraph 54, or 53 actually, which is the one that I referred you to, is not the full story. That's simply part of the overall conclusions. For the full story on what the LDP reporter thought about Greenbelt and landscape impact, one needs to go back to pages 493 and 494, and it might be worth looking at those.
Of the examination report?
Yes, sir.
Okay.
You got that, sir. So there's a section which begins paragraph 17, Greenbelt and Landscape Impact, on page 493, and I'll not read you or take you through all of that. That's the sort of the background, the analysis, and so on. But of particular importance on page 494 are paragraphs 23 and 24. So the reporter says there, once the major public transport infrastructure developments are complete around Gogar and development is underway at the International Business Gateway and Maybury, I consider the distinction between urban and rural on this edge of the city will become relatively less defined. The site lies between the bypass and the not inconsiderable development associated with RBS headquarters. I have not disagreed with the Council's decision to retain the land associated with the bank operations in the Greenbelt. However, I consider the access and overbridge combined with the extent of development on the other side of the road serves to signal arrival within an urban area. So there the reporter is setting out her views on what the character of the area will be, certainly, once the development in the LDP is underway. She then goes on in paragraph 24, in conclusion, I consider there would be a significant localised impact on landscape, particularly in the context of loss of an open view to the Pentlands and the countryside setting to the west of the bypass. I do not consider there would be a significant impact on the wider quality, character, landscape setting and identity of the city or on recreational access. The development would not raise issues of coalescence. And then she says, however, she accepts that the bypass currently provides a strong and consistent boundary to the Greenbelt. So again, I would say that on any fair reading of those two paragraphs in particular, that reporter was reaching conclusions that the development of this site would accord with policy 7A of the SDP.
Just to make a further point, Mr. Welton referred to paragraph 54 on page 500 and referred to the sentence, I consider the extent of existing constraints to future development are significant and sufficiently uncertain at this stage as to caution against weakening this long-established Greenbelt boundary. my impression from reading the report as a whole is that there were a number of issues that the LDP examination reporter felt, at least two important issues, that she didn't have enough information on at that stage to reach a view as to whether this application site should be allocated in the plan. Probably most significantly, the further work to be undertaken on cumulative transport impacts and also the issues raised by SASA. And that was the reason why the reporter felt that they couldn't remove land there from the green belt at that stage. And of course those are issues that you'll be considering in some detail.
Okay, that's useful. Mr. Welton, anything more on that?
Nothing, sir.
Okay, thanks for that. So, moving on. Criterion B in Policy 7 is that the development will not undermine Greenbelt objectives. Is there any, I know that there's a lot of material before me on that. Is there anything that we can usefully discuss on that today?
Again, sir, sorry. Appreciate Sir West Craigs to take the lead there. I think in large part we'd rest on what's in the hearing statement. As Mr. Holders just identified, the examination reporter drew a clear link between the Greenbelt boundary and the maintaining the existing Greenbelt boundary or weakening that to allow this development to go ahead and addressing constraints.
Mr. MacLeod, Mr. Holder.
If it didn't come up in the section that Mr. MacLeod read from the examination report, I think we'd rest simply on the point that the LDP examination reporter, although identifying that the city bypass was a strong and defensible boundary, was satisfied that a new boundary could be created in relation to the application site, and that it would be a strong boundary.
Okay. And criterion C is that any additional infrastructure required as a result of the development is either committed or to be funded by the developer, and that really takes us back to the whole infrastructure issue, which I'm clear on in the hearing statements and which we've discussed a little this morning. So unless others indicate otherwise, I think we've got sufficient information on that.
Sir, just one point
Mr.
on
Craig.
that. Yeah, obviously in terms of the definition of infrastructure, which is on page 61, I think, of SES plan, the definition includes, I won't go through the list, but includes public transport and roads. And the requirement in terms of criteria C is that any additional infrastructure, which includes roads, resulted in required as a result of the development is committed or funded. So I suppose the requirement in terms of that criteria is to have some degree of confidence that the required roads infrastructure will in fact be delivered.
Yes.
Now obviously we're coming on to that. The point I'm only making at this point, to lay down a marker, is that all of the roads mitigation proposals rely on land which is in control of RBS, which obviously raises certain issues.
Thanks for reminding me of that. And clearly, for that criterion, as with other policies, our consideration at the future session on transport impacts will feed back into my conclusions on these policies. Yeah. Okay.
Sir, just so that West Craig's position on this is clear, if I can, on education infrastructure, as well as SES Plan Policy 7, there's also the provision in the spatial strategy of CES Plan on page 6 that new development proposals will complement and not undermine the delivery of existing committed development. And I'd understood, and Mr Alexander can correct me if I've got this wrong, but I'd understood from the Council's evidence this morning that as far as education infrastructure was concerned, it was the Council's position that the provision of education infrastructure for this site would not undermine the delivery of education infrastructure HSG 19. It's obviously key to West Craig's position on CES Plan Policy 7 in terms of education.
Okay, I take that point. Okay, moving on then, and I'm a little nervous that we might be getting into Richborough territory here now, but can we discuss, in the event that I do find a shortfall in the effective land supply, which of the policies of CES Plan should be considered as being out of date in accordance with paragraph 125 of SPP? i.e. which shouldn't be applied to my assessment of the site?
I think we probably are firmly in Richborough territory now.
Sadly, I think so.
Shall I tell you what I think it means?
Okay,
and I'll try and keep it as simple as possible.
And ultimately, as you've already said, this is going to have to feature in submissions given the late introduction. But yes, I'd like to hear that now nonetheless.
So in essence, my understanding of what the Supreme Court is saying is that the important issue here is not whether any particular policy is one for the supply of housing land. But simply whether there is a shortfall.
Okay.
If there is, then in England, the presumption in the NPF kicks in. And I think the same position applies in Scotland. Now, what the Supreme Court seems to be saying is that if you find there is a shortfall, then as a matter of fact, the housing strategy policies are not delivering what they need to. And it then falls to you as decision maker applying your planning judgment to decide how much weight should be given to any policy in the plan. Now, in this case, I think that then has to be seen in the context of what SPP says. And what SPP says is that the presumption in favour is a significant material consideration. So that, I think, is all that I want to say on it for the moment. And
Okay.
I'd be interested to hear whether other parties agree with that or not.
Okay. So, and I will come to you, Mr. Wilton. What you're saying, your reading of the judgment is essentially that there's a more nuanced position to be applied in terms of what weight to be given to into policies rather than a black and white, this policy's out of date and then no longer therefore applies.
Yes, and I suppose the approach that the courts had taken up until the Supreme Court judgment was that although policies were or housing policies may have been out of date, they weren't disregarded altogether. They still had some weight to be given to them. It might be very little, but you couldn't disregard them altogether. They were still there. What the Supreme Court has said, as I understand it, is all of the other courts were wrong to try and specifically pigeonhole policies into ones for the supply of housing land and ones which were not. And what the Supreme Court... Sorry, I'll let you finish that. And what the Supreme Court was really saying is the important thing is if there is a shortfall, then your plan is not delivering. And certainly that is a significant issue. Certainly in the context of NPF, I would say it's a significant issue in the context of our national planning framework and Scottish planning policy as well.
In terms of the presumption in favour of
yes, in terms of
sustainable development.
I mean, I suppose I could go back to, and it perhaps is worth actually just having a very quick look at Scotland's NPF, which I think has been lodged by Mr. Gregg as one of the RBS documents. And you might have to just bear with me for a second while I find that.
It's RBS 1 as far as I can see.
Yeah. So if you go to page 13 of the Scotland's Third National Planning Framework, and this is a section in the context of Edinburgh in the southeast, and you'll see about halfway down that page, it says the CESPLAN area is projected to have the second largest rate of growth of the 4 SDPAs, 20% increase in population and 32% increase in households between 2010 and 2035. A planned approach is required to ensuring development needs are met whilst taking into account existing and future infrastructure capacity. Led by CESPLAN, we, the Scottish Ministers, wish to see a greater and more concerted effort to deliver a generous supply of housing land in this area. So that, for me, is a very clear indication of what Scottish Ministers want to see happen within the CESPLAN area. Now, CESPLAN itself sets the requirement. It took us some time to get to that point, as you'll appreciate from what you've seen. We had a deficient CESPLAN, new supplementary guidance, then a deficient LDP, and what we have is a situation where the numbers, the requirement for housing approved by Scottish ministers is still not being delivered. So the message that's coming through, I think, loud and clear from the NPF is we need a more concerted effort, which in my submission means placing significant emphasis on the shortfall and ultimately, if required, less emphasis on policies that restrict housing development or would otherwise restrict housing development if there was no shortfall.
Are such policies still to be considered as being out of date, though? Does the judgment move away from that sort of territory? Presumably that language is still in SPP.
It is still an SPP, and I mean, having discussed this out with the hearing session with Mr. Welton, I think there's probably a collective view that the judgment's a bit circular. It explains that if there's a shortfall, the strategy is not delivering. It then says it's really up to you to decide how much weight to apply to any individual policy within the development plan. But that in doing so, you have to take account of the objectives of, in England, the NPF. In Scotland, I would say our national planning framework and Scottish planning policy. And those objectives are to deliver more housing to meet identified requirements.
Well, those are one of the objectives.
They are, indeed.
Thanks for that. Mr. Wilton.
Thank you, sir. We might come back to the incorporation of MPF3 into this point. I was, I think, largely agreeing with Mr. MacLeod on much of what he said, but to pick up your point about policies being out of date or not, the key issue in the Richborough cases has really been about what is meant by relevant policies. And I think our previous submissions before the Supreme Court case, before the Supreme Court judgment was available, was that insofar as the applicants have made submissions on this point in terms of the LDP, they haven't, I don't think they've made submissions on it in terms of CES plan, but that they've perhaps overstated the position. But what people were concerned about was whether you took a narrow or a wide approach to relevant policies. And the Court of Appeal had taken the wide approach. I won't read through it, sir, but for your notes, paragraph 48 of the Supreme Court judgment sort of gives an explanation of what's meant by narrow, wide, and then intermediate. And relying on the wide approach, the applicants had said that greenbelt policies should be treated as out of date. The Supreme Court, on that point, has said that it's adopting the narrow approach, which means relevant policies are the policies concerned with the positive delivery of housing. But then I do agree with Mr. MacLeod in that from that point they then go on to say it's then for you, sir, as the decision maker to make a planning judgment. But insofar as SPP refers to this in paragraph 33, where relevant policies in a development plan are out of date, I don't think, given what the Supreme Court has said, you can apply that to greenbelt policies now. So it wouldn't be appropriate to consider a greenbelt policy a relevant policy and then immediately treat it as out of date. And one element of the case which I think is helpful is where the court says that this approach of treating policies out of date or otherwise is particularly inappropriate as applied to fundamental policies like those in relation to greenbelt or areas of outstanding natural beauty. No one would naturally describe a recently approved greenbelt policy in a local plan as out of date merely because the housing policies in another part of the plan fail to meet the MPPF objectives. And I think that's where we are.
So, in other words, a greenbelt policy and a recently adopted LDP isn't to be treated as out of date. So it's not black and white, but that it's still open to the decision maker to reach a view on what weights to be given to that policy, in other words.
So if I could just supplement that by tying into the NPF3, I think the same logic would suggest that you wouldn't just necessarily set aside other matters relating to West Edinburgh, in this case, that have been set out in the LDP. The NPF talks about taking a planned approach. The specific reference to the major investment location that West Edinburgh is, with specific examples given. So I think the consideration of where a housing land shortfall sat would have to be part of that wider consideration, particularly where it talks about a planned approach, taking account of existing and future infrastructure.
Okay, thanks for that. Anything to conclude on that, Mr. MacLeod?
Perhaps just a couple of points in response. As Mr. Mappin says, the NPF3 clearly envisaged a planned approach to development within Edinburgh and the CES plan area. That planned approach has failed to date. I don't think there's any disagreement between us and West Craigs on that matter. What we now have is a plan which contains a framework to rectify that deficiency. And I suppose that can be found in both policy CES Plan 7 and How 1, which we'll no doubt come on to discuss. I think the only other point that I would want to make is that, as Mr. Welton says, there is specific reference in the Supreme Court judgment to Greenbelt and areas of outstanding natural beauty. But that reference has to be read in the context of what NPF itself, the English NPF, actually says. And I can put this in submission, but what you find, in short, what you find when you look at the NPF delivery policy is if policies for delivery of housing are out of date, then you go to effectively a release policy which says that planning permission for housing development should be granted unless, and then there are two specific caveats. One of those caveats is where specific policies indicate that planning permission should not be granted, and Greenbelt and areas of outstanding natural beauty, I think, are both mentioned in that policy. And I'm sure you appreciate, sir, that the way that the English planning system treats Greenbelt is very different to the way that the Scottish planning system treats it. The Greenbelt in England, perhaps paraphrasing, is pretty much sacrosanct, whereas in Scotland I would suggest that it is more flexible, and particularly so in a case where there is a shortfall in the land supply. Yeah, exactly. And the reason I say that, particularly in this case, is that Policy 7 of CES Plan does not preclude the granting of planning permission in the Greenbelt. And that is different to how the English NPF is set out.
Okay, thanks for that. Anything more on that, Mr. Welton?
Sir, I think it'd probably be easier if we deal with the rest of it in submissions, if that's okay with you.
I'm in favour of that.
Yeah. Might be points about the English system that we might not completely agree on, but I think it's probably easier just to do it that way.
Good. That was all I had on CESPLAN then, other than Policy 7. You know, I'm clear on how I need to apply the other policies, depending on my various conclusions. So, moving on to item 4 on the agenda, which is assessment of the proposed development against the policies of the Edinburgh Local Development Plan. And similar to our discussion on CESPLAN, I'm clear on the application of the various topic-based policies within the adopted LDP. So, for the purposes of this session, I'd like just to concentrate on policy how 1. So, first of all, can we work through the 5 criteria set out in part 2 of policy how 1, taking the just as we have on CESPLAN, taking the parties' views on each in turn, although clearly criteria A to C reflect the same criteria set out in CESPLAN Policy 7, so I'd suggest that we start with criterion D.
So there was one preliminary point in terms of policy how 1 and the triggering of part 2, and it was really just to bring us to your attention, because I was mindful that the council are not here to give any development plan evidence, and I won't ask you to dig it out, but in terms of the Council's assessment of the West Craigs application earlier this year, where the reports committee is West Craigs document 7, and it's page 10 of 91, and that sets out the Council's position on housing land supply, which I think largely mirrors the hearing statement that's been provided on that issue, and in particular relies on the 2016 housing land audit. It was simply to bring to your attention that the council in that case did feel able to go a step further, and it was their position that if you were to agree with the council's assessment on housing land supply, that policy how 1 part 2 would not apply. Not making any comment on whether that's correct or not, sir. You'll appreciate, but I felt it was there in the absence of the council having a position for this process.
Yes. And that would be consistent with the council's view on housing land supply that we heard this morning.
Yes.
Okay.
But I'm assuming, just for the avoidance of any doubt, that when West Craigs takes its appeal against refusal of planning permission to one of your colleagues, it will be arguing that there is a shortfall in the 5-year land supply.
I think it's clients left the room. If West Craigs bring an appeal, is all I think what I can say on that. I mean, the West Craigs proposal is quite different in that there's no housing proposed on Greenbelt land. This is about delivery of an access, which Mr MacLeod will be familiar with from the Taylor Wimpey side. So it's not directly comparable. We haven't, for the purposes of this process, taken a view on housing land supply because West Craigs is an allocated site.
But just to be clear, is West Craigs agreeing that the terms of policy how 1, 2 are engaged for the purposes of this application?
I don't think we need to, sir. I think all I was bringing to your attention was that if you agree with the council and their approach, part 2 is not engaged. If you agree with the applicants, then I would agree that part 2 is engaged.
And West Craigs is agnostic on
Absolutely.
Yes. I'm surprised Mr Welton's so agnostic about the point. It's a fairly simple one, and I would have thought that both he and Mr Mapham have got very, very clear opinions on whether there's a shortfall.
Well, as I said, sir, Mr Mappin and myself are appearing for West Craigs, who are an allocated site, so thankfully issues of housing land supply are not directly, shouldn't be directly relevant to them.
Okay. So, back to part 2 of policy how 1, and as I've said, it looks to me as if criteria A, B and C simply repeat the similar criteria set out in CES Plan Policy 7, which we've already engaged, of which we've already considered. So that takes us to part 2D of Policy How 1, which is that the site is effective or capable of becoming effective in the relevant time frame. Now, that brings the letter that's been handed to you into play, Mr Wilton. Would you prefer for us to break for lunch now to give you time to consider that?
That would be helpful, sir. I'd also probably highlight that in terms of the site becoming effective and the various interventions that are needed, whether it's education or transport or whatever, I'm not sure how well placed we are at the moment to come to a complete view on that. I think part of what we've said is to highlight interventions that are required for transport or the applicants might say are not required, and it's not quite clear how those will be delivered. So I think I would suggest you have to understand what is required to allow the site to come forward, to then make a judgment as to how effective it is or not. And I think we're in a slightly difficult place on that at the moment. In terms of issues of ownership, it would be helpful to have some time to consider this. But on the infrastructure elements, which I think are probably more significant, I'm not sure how much we have to say or how much information we have to do that.
In as far as the transportation impacts are still to be considered, that's right. But, you know, I've said earlier that I'm more than happy to hear the parties' views subsequently on transportation impacts and import those views back in to application of this policy. So we can take discussion on this as far as we can today.
I think that's fair comment. What Mr Welton said is absolutely fair. In terms of the transport side of things, you'll appreciate that his clients have raised a number of issues about land ownership associated with those. And I think the point that Mr Welton may be getting to is we've got there's an evolving process in relation to transport infrastructure. That's going to be the subject of a subsequent hearing, and it's my intention to address those sorts of issues as part of that hearing once, as he puts it, we've got more detail on what the actual infrastructure is.
Yep, and that seems a reasonable way forward. Okay, so shall we take a lunch break just now then? I'm aware it's a little early, but I think Mr Wilton needs a little time to have a look at that letter. I'm also conscious that Mr Houghton may or may not be joining us this afternoon, and he wanted to be involved in discussions on development plan policy. So to try and be as fair to him as possible, if we take our lunch break now so that we're continuing development plan policy discussions into the afternoon in the hope that Mr Houghton will be able to join us by then. So let's break now. We're making good progress. I'm fairly hopeful that we'd be able to get through the remainder of development plan policy considerations and probably complete the conditions and obligations session this afternoon too. So if we break now until say 1:10. Okay, thanks. Everyone, I'd like to make a start. We were moving on to consider the proposal against the policies of the Edinburgh LDP and specifically policy How 1 Part 2. Mr. Welton, you were handed a document just before lunch. Any comments on that?
Thank you, sir. Mr. McLeod's confirmed that the letter is undated, but it's 22nd of May 2017 is the date of it. So that was my first question, but he's resolved that for me. I think very limited comments are that from our perspective, we don't feel it really takes things much further forward.
Sorry, first of all, are you happy for it to be submitted?
Sorry, yes, I should say that.
Yeah.
Apologies, yes.
Okay,
yes, no
could I have a
objections
copy of that then? Thanks. Do you have a document number for that?
Yes, I think it was M145.
Yeah, it was M146. Thanks for that.
Sorry,
Mr. Welton.
I've forgotten it hadn't actually been lodged. Yes, sorry. From Westgrave's perspective, don't feel it really moves matters on from the email, which is M27. Which is an email of the 20th of November 2015 from Mr. Rafferty, who's the author of the letter. It's a signal of intent. It's in no way binding. So I don't really think we've got from that perspective any more to say on it, though. I think Mr. Mappin might have a comment.
It might be useful just to go back to the applicant first of all and ask them in the context of criterion D of policy How 1 Part 2, what significance should be attributed to this, and then we can come back to you. Mr. MacLeod.
Yes, sir. I think, so we're just hunting for the LDP. If one considers the PAN criteria on effectiveness, which is obviously what How 1-2D is I suppose, getting back to. What this demonstrates, I would say, is that the site is in the control of a party who can be expected to release it for development within the relevant period. And as you'll see from the terms of the letter itself, very shortly after planning permission principle is granted. I think we're talking about a period of 6 months.
Which part or proportion of the application site does Mr. Rafferty's landholding extend to?
I think that's shown on one of Mr. Welton's documents, which WCL 20, I think, is probably the best document to go to.
Okay.
So it's essentially the chicken farm.
Okay. And as far as criterion D in its wider sense is concerned? comments on that?
Well, the starting point in our views at the site is effective in the period it needs to be. We've set out a programming in the hearing statement. As you're aware, previous documents have identified interested house builder parties. So there are at least 3 potential developers of the site. In our case, subject to further discussions at other hearings, we don't believe that there are any constraints to the development proceeding. So that's it in a broad sense, but if you want to ask some more specific questions.
Okay, happy with that. Mr. Wilton, anything more either to say specifically on that letter or in the wider sense?
Yeah. Yes, so just a couple of brief comments. The policy test talks about the site, so I'd understand that to be the application site. Notwithstanding the general terms of the PAN, one might have expected, given the crucial role this site plays, to have understood a bit more about the mechanism and the timing of it, because it's not just a part of the site that might be reprofiled in programming terms to pick up any shortfall in how quickly you bring it forward for specific development. But because of the terms of draft condition 3, it highlights its role as a crucial fundamental part of delivering the whole site. And I understand the conditions framed to limit occupation until the poultry farm is relocated. So it takes on a slight enhanced status in the overall effectiveness. It's not to suggest, obviously, that the principal part of the site isn't effective. I think that would be accepted. But as I say, that perhaps an expectation would have understood some more detail about the delivery of this part of the site in the wider site effectiveness context.
Would the PAN specifically require that sort of detail? Also, would the PAN require there to be a legal agreement in place, or would this type of letter of comfort be sufficient for the purposes of the PAN test?
Well, the PAN test isn't specific in relation to the status of where you needed to reach in relation to a third-party agreement. As I say, it's the specifics of this case. You might have expected some more progress to have been demonstrated on that because of its crucial link to delivering the whole site in an ownership sense.
Okay, and any comments on the effectiveness of the site in its wider sense, beyond the ownership issue?
So West Creek's submissions that relate to delivery of infrastructure in terms of education infrastructure and transport. I don't think there's much we can add to what's been said this morning and pending the transportation session.
Okay, thanks for that. Mr. MacLeod, anything more on that?
Just a brief response in relation to the letter, and I appreciate that you've only just seen it, but to pick out a couple of highly salient points. The owners of the site are indicating that, firstly, they've identified a suitable relocation site for their business. Secondly, they've decommissioned half of their operations already. They go on to talk about the benefits of the relocation, although that's not relevant to the question of effectiveness. But then most critically, they say that they are committed, if planning permission in principle is granted, to selling our land to our selected delivery partner and would be in a position to fully vacate the site within 6 months of the permission being issued. Now, looking at that time frame in conjunction with the estimated programming set out in 4.11 of the applicant's hearing statement, we are not projecting completions until 2019. And I suppose clearly a matter for you and Scottish ministers, but if planning permission was to be granted, I'm assuming that that would be sometime late 2017. So the vacation exercise, or the relocation exercise, would be undertaken at the same time as AMC applications were being progressed and the other infrastructure requirements on site, for example, the Gogar burn and so on, that we'll perhaps come on to discuss at the hearing session, while those things are happening too. So in essence, any concern that Mr Mappin might have regarding the restrictive nature of draft condition 3 is not something that you need to be concerned of in my submission.
Okay, anything more on criterion D?
Sir, just from me, obviously, I need to reserve RBS's position as regards infrastructure for the future hearing. But obviously, as things stand, again, I made the point earlier on that a large part of the roads are under RBS's control, which may be relevant.
On this criterion specifically, I mean, I formed the view, and I may be wrong in this, but I formed the view that there is potential at least for RBS to reach agreement with the applicant for those road improvements to be carried out. Have I been wrong on that, or is that potential still there?
Well, that rather remains to be seen, but certainly as things stand, as of this point in time, there is no agreement. And certainly on the basis of the last mitigation scheme which we saw, which is the one just before the hearing just now, there is no agreement on that, and there is no prospect of agreement on that. I suppose we'll need to see what comes out from the latest material, but I think realistically, so the potential difficulty with that is that, certainly as I understand the position, we had been proceeding on the basis that the transport assessment which had been undertaken took into account the traffic flow from committed development. Now, it transpires that that isn't quite correct, and so as I understand what's happening, there's revised traffic flow information being produced, which does now take into account traffic flow from committed development. Now, that is going to presumably add additional traffic, to some extent anyway, into the area which we're talking about, and that it's difficult to see how that will improve matters, how that will be more likely to result in an agreement on road mitigation than the current position. So that's the difficulty we're in terms of the parameters that we're talking about. It's rather difficult at the moment to see how agreement could be reached.
But that remains to be seen based
on
the
information
that's been
yes, I wouldn't be as optimistic perhaps as you had been perhaps thinking.
Okay, thanks for that. Mr MacLeod.
I think without wanting to prejudge any of the transport evidence or any of the figures that are going to come out and be discussed over the next couple of months, for the purposes of your perception at the moment, what I would say is that there is still a discussion going on between my clients and very senior officials in the Royal Bank of Scotland with a view to finding a solution. So I wouldn't like you to leave this hearing with the impression that there is no dialogue taking place. The dialogue continues, and certainly my clients are hopeful that a solution can be found.
That's quite correct, sir. Dialogue does continue. All I'm saying is I would exercise a bit of caution.
Okay. I think that's all I need on that, and that it remains to be seen what comes out of those negotiations and our hearing session on transport impacts. Okay, that was criterion D. Criterion E is a bit more widely drawn. The proposal contributes to the principles of sustainable development. I mean, my feeling for that is I'll need to reach a view on that based on the evidence in the round, but is there anything that the parties wish particularly to draw to my attention? Mr. Wilton?
No, sir, we rest on our written submissions.
Thanks for that. Mr. MacLeod?
No, sir, I think we're happy that you've got sufficient information to reach a view on these things.
Okay, thanks for that. Now, I had the same question that I posed this morning in relation to the CESPAN policies, i.e. which of those should we take to be out of date if I find that there's a shortfall in the effective housing supply. I don't think we need to rehearse those sort of in principle arguments. I'm assuming that everyone would agree the same applies to the LDP policies as it does to the CESPAN policies. I did have one specific question on that though, and I'm referring to paragraph 413 of the West Craigs hearing statement, where West Craigs appears to be making the case that if there's a shortfall, policy how one should be read as being out of date, which puzzled me, and I was wondering if I'd misread that, because if there was a shortfall, surely the mechanism for rectifying that would be policy how one.
Yes, sir, I think what we were referring to at 413 is our understanding of the applicant's position. West Craig's position is that policy HOU1 does apply, whether there's a shortfall or not, because it provides the mechanism to deal with that. I think where there may be a difference between us is in terms of whether you apply the whole policy HOU1, which is West Craig's position, and the applicants, I think, are saying that they say you discount paragraph 1 of HOU1 and treat it as out of date. Or maybe not.
Mr. MacLeod?
No, I don't think that's what we're saying. I mean, I suppose if you go back to the point in time when this was written and the Court of Appeal's decision in the Richborough Estates case, what we were saying is housing policies are out of date, as a matter of fact. And our position then was not that you discount any policies in their entirety. You certainly can't ignore any of those policies. But our position was that policies that restrict the development of housing should therefore be given significantly less weight.
Okay.
Now, I still say that is the case. I've told you what I think Richborough Estates means now. But in essence, what it says is, if there's a shortfall, then something needs to be done about that, it's then a question for you as to how much weight to apply to any individual policy. But in my submission, a policy, we can see this to an extent from the West Craigs hearing statement, because what they suggest is that this is greenbelt, and housing is not, housing of the sort proposed here is not an appropriate use within the greenbelt. Now, if you that greenbelt policy is clearly there, but it needs to be read in the context of the other policies in the plan, including policy How 1, Part 2, and that specifically says at the outset, where a deficit in the maintenance of the 5-year housing land supply is identified, green belt housing proposals may be granted planning permission where, and then certain criteria are identified. So in other words, green belt in my submission should not be given the same weight as it would normally if there was no shortfall.
Because Part 2 of that policy is triggered in a shortfall situation.
Yes.
So
yeah. Maybe that Mr MacLeod's we've not expressed this clearly, or he's misunderstood it. West Craig's position is that if a shortfall was demonstrated, then as part of policy HOU 1, you do look at paragraph 2 and development greenfield greenbelt, paragraph B in particular. Development will not undermine greenbelt objectives, and that's set out in paragraphs 411 and 412 of our statement, which, as with the applicants, predated the Supreme Court decision on Richborough. So it's not West Craig's position that you should only apply the Greenbelt policy ENV 10. I think in fairness, we do recognise that if a shortfall is demonstrated, one goes to Part 2 of HOU 1, and that provides the mechanism. From West Craig's position, when you do that, you still need to have regard to the priority to be given to the delivery of housing land supply and the sites identified in criteria in paragraphs 1A through to D. And even where there is a shortfall, you shouldn't lose sight of that priority.
So you would agree on that point that due to the wording of the policy, greenbelt sites can be looked at once Part 2 is triggered, but you point me to Part 2B that says you still must bear in mind greenbelt objectives.
Yes, sir. I think policy HOU 1, paragraph 2 is in a way largely replicating CES Plan Policy 7 and probably SPP as well, and in that respect. So yes.
Okay. Okay, I'm happy on that, unless you've got something more to say.
Just one point, and I think it's probably, you'll probably appreciate this already from what you've heard this morning, but in light of what the Council's education officials said this morning, I don't think there's any suggestion that this development would prejudice any other allocated site, including Mr. Welton's clients.
In regard to education provision, in any case?
In regard to that, and well, you obviously have a transport session to consider in due course, but in my submission there's no evidence before you at the moment that suggests that development of the Murray Estates site would prejudice any other allocated site in the LDP.
Sir, on that point, I think we're in agreement. That was my understanding of the Council's evidence on education, that as far as the Council's concerned, this site will not prejudice the delivery of HSG 19.
Yes.
And whatever solution they come to on education, they will do whatever it takes, seems to be the impression I got this morning, to ensure that that's the case. I think perhaps something of a watching brief on that from West Craig's perspective, given where the supplementary guidance is and the Scottish Government's position on that. But yes, I'd agree that from what we heard this morning, the Council's position is that there's nothing about granting this site in education terms that prejudices delivery of West Craigs.
Yep. Okay, thanks for that.
Just maybe one point of clarification then. Does Mr Welton want to withdraw his objection to this application, or at least the part of his objection that suggests it might prejudice the development of his client's site?
On education grounds?
Well, yes, on education grounds. I'm not sure that he has a point in relation to anything else at this stage.
I think the indication I'm getting is that there's going to be a polite no to that. The Council, we've heard what the Council said this morning. As I said, it's clearly something of a movable feast in terms of exactly where they're going to land. It may be that if the Council was able to provide greater certainty to reflect its evidence from this morning, that I would be able to take that away and consider it with my clients and see if it is possible to get to that position. The evidence was heard, but it's not in the papers, if you like. So if the Council are able to provide something, to provide that certainty, then very happy to could consider it with our clients and take it from there.
Okay, thanks for that. So there's maybe some mileage in that, but we won't get a definite answer on that today. Okay. And one final question on the LDP policies generally. Do the parties think or agree that a positive finding on Policy How 1, Part 2 having been triggered and so on, that a positive finding on that would override other topic-based policies such as Policy NF10 on Greenbelt development, or is it not as straightforward as that?
Discussing as to whether you want a lawyer's view or a planner's view, so you might get two views from...
One that I can understand would be preferable.
Planner's view. I think I take the view, I mean, it's not one I've thought of, that Policy How 1 should be enough for you to determine the principle of granting planning permission. It sets out the things that you need to take into account to grant planning permission. I think that's too simplistic, but I don't know if Mr MacLeod has a different view.
And I could find policy NF10 on green belts is offended, but that a positive finding on Policy How 1 would override that.
Yes.
Or outweigh it anyway.
Yes.
Yep, I'm pleased to say I do agree with Mr Holder, and then I will give you a legal basis for it as well, which can be found in the hearing statement and paragraph 2.2.
Yep.
And this is the quote from Lord Clyde, where he talks about essentially what your role in this process is, sir. So it's necessary for you to consider the development plan identify any provisions in it which are relevant and make a proper interpretation of them. Next sentence we can skip. He will have to consider whether the development proposed in the application before him does or does not accord with the development plan. There may be some points in the plan which support the proposal, so that would be how 1 in this example. There may be some that point in the opposite direction, so your ENV10, inappropriate development in the Greenbelt. He will require to assess all of these and then decide whether, in light of the whole plan, the proposal does or does not accord with it, and then it goes on to material considerations. So in this case, what we have is an acknowledgement that more housing land needs to be found. A policy that sets out the criteria for finding those sites. And then a range of other policies that that would apply with more rigour, I would say, if there wasn't a shortfall.
Okay, thanks. Mr. Welton, anything to add to that?
It's probably just a slightly different way of saying the same thing in relation to looking at the clearly HOU1 is there to perform a function. Whether it covers all the relevant matters that other policies cover in whole or part will be down to interpretation. And I think specifically it covers the scenario of sites that are greenbelt, albeit the specific policies that apply to sites designated for greenbelt, which of course the site has been designated in an up-to-date LDP as greenbelt. So there will be a number of overlaps, but there may be some policies that remain on a standalone basis that you'd have to give due consideration to.
But that ultimately there's a balancing exercise to be carried out. Yeah. Okay. Anything more on that?
Sir, can I just add one point there?
Mr. Gregg.
Within our hearing statement, we referred you, sir, to the special economic area development policies relating to RBA Skogerburn. And Mr. Wilton already referred to part of CES plan that emphasised the point about new development not detracting from existing committed development. All of this, I think, sir, all frankly, as far as we're concerned, really comes down to the issue of transport infrastructure anyway, and I suspect would be taken account of in terms of criteria C of how one. It's really just to point out there are also economic development policies which are potentially relevant as well that might need to be part of the balancing exercise, depending obviously on what view you came to on infrastructure.
Yes, I think you're absolutely right on that. I was using the Greenbelt policy as an example of a sort of topic-based policy that would need to be taken into the balance, but I take your point on that. Okay, well, those were the questions that I had on the application of LDP policy. Is there anything else on that that anyone feels we should really discuss today? Nope. Okay, so moving on to item 5 on the agenda. Any other matters generally on housing land supply or development plan policy that we should consider before closing this session?
Just maybe a point for the end is about timing for submissions on Richborough, whether you wanted those as part of this process or to wait and hold it over until
yes.
considered other matters.
Maybe if we're moving on now to the conditions session, maybe at the end of that we'll take stock of where we are with a whole range of issues like further procedure, closing submissions, site inspections. Okay, great. So that's the development plan and housing land supply session closed. And I think we can move on to the conditions session now. The Council's taking part in that, I'm assuming. You're ready to do that, Mr. Alexander, with some help. Okay, is everyone ready to start that session? Yep. Okay, I don't think we need to go through the usual preliminaries of introduction and so on unless there are any new participants in this session. Mr. Alexander? No? Yep. Okay, fine. So item 2 on the agenda, I just wanted to check that I have the information that everyone thinks I should have. So on this subject, I have a hearing statement from the Council with a schedule of 18 conditions attached as Appendix 1, a statement of agreed matters on infrastructure between the applicant and the Council, hearing session statement submitted on behalf of the applicant, RBS, and Dr. Scott and Mr. Harrison. And West Craigs, in addition, have commented on conditions through their statement on infrastructure, and specifically at paragraph 5 of that statement. I did, in addition to that, take comments on conditions from SASA in the inquiry session earlier this week, and we discussed those potential conditions and obligations yesterday, so we don't need to do that today. And as advised previously by email, we won't be considering any transport-related conditions or obligations today. We'll pick those up at the end of the hearing session on that topic, still to be arranged. So, moving on to item 3 on the agenda, and that's the consideration of proposed planning conditions. The Council had intimated in its statement on conditions that discussions were ongoing between the parties in order to reach agreement where possible. Are there any updates on that, or are the 18 draft conditions the most up-to-date position between the parties?
Yes, that's the case, read alongside Bury Estate's hearing statement on conditions. That, as I understand it, is the up-to-date position.
Okay, thanks for that. Now, the agreed statement on infrastructure indicates agreement between the applicant and the council to limit the development to 1350 units by condition and to specify the split between flats and dwellings. And my first question is, why is that necessary? Is it to conform to the indicative development framework that's been assessed through the EIA, or is it for another reason?
It's not so much to do with the indicative development framework. The indicative development framework and the environmental statement were based on a maximum of 1,500 units. The 1350 and the split that's proposed really relates to the provision of education infrastructure. And the reason that those numbers are suggested is that is the indication of how things will be taken forward on site, following discussions with delivery partners on the ground.
So it's coming from that side rather than from the council's education service saying that's the maximum we could deal with. It's just a development of the applicant's thinking of what's likely to happen on site.
That's correct, sir. And that then feeds into what education infrastructure would be required. So rather than having a scenario where the development is simply conditioned with maximum of 1,500, no split at all, which might then give rise to a much larger education infrastructure requirement, the feeling was that it was appropriate at this stage to set out those limitations.
And a condition along those lines doesn't appear to be included in the schedule of draft conditions.
That's correct, sir. The draft conditions, as Mr. Alexander says, you have the draft schedule of conditions proposed by the council and our hearing statement, which came after that. And that really responds to the conditions and sets out where we think further amendments would be appropriate. So in our hearing statement on conditions, we've suggested that, this is paragraph 2, that those limitations should be included within a condition.
And would you be proposing to work with the council to provide a form of words for such a condition?
We certainly can do, sir. I mean, if it would be helpful to you following this hearing, we can provide you with something that is an updated version of where the parties both sit on those.
That would be useful.
Yeah.
Yep. And a question for you, Mr. Alexander. If that condition was to be agreed between the applicant and the council and included in the schedule of conditions, do you agree with the applicant that that could lead to the, or should lead to the deletion of proposed condition 10?
Yes, we would agree with that approach.
Okay.
So picking up something from RBS's hearing statement, they contend that paragraph 2.1 that an additional condition is needed to restrict the development to the parameters of the environmental statement. Comments on that from the applicant?
Yes, again, I think this is covered by paragraph 2 of our hearing statement, where we've said we accept that this condition, condition 1, should require the master plan to conform to the indicative development framework assessed through the environmental impact assessment process, unless otherwise approved by the council. So in other words, and it then goes on, we also accept the condition should restrict unit numbers or floor space to the maximum levels assessed as part of the EIA process. So in essence, a revised condition 1 would be tied to the indicative development framework and the environmental information which you had considered as part of this process.
Okay, council happy with that?
We are happy with that approach, yes, sir.
Okay, and Mr. Gregg, RBS happy that that responds to the point made in your statement?
Well, obviously, sir, my remit here is rather limited. We're really only concerned with transport and ensuring that the transport mitigation is appropriately secured by means of the conditions. But I suppose the only thing I would say, sir, is the indicative development framework, as I understand it, is purely a plan. And as I understand the ES effectively assesses impacts within a kind of three-dimensional conceptual framework in terms of maximum heights and the like. Again, it's not really a point that's particularly important for RBS's interest, but I wonder if the condition might need to be slightly wider than is perhaps being suggested to incorporate the parameters within which the environmental impacts of the development were assessed. I'm not sure that the framework by itself would necessarily be sufficient.
Mr. MacLeod?
I think we have to recognise that, well, firstly, this is an application for planning permission in principle. We certainly accept it would be appropriate to restrict floor space to those to what had been assessed through the EIA process. Mr. Gregg's concern, I think, relates back to two cases from the late 1990s, early 2000, to do with development of a major mixed-use development in Rochdale. Things have moved on somewhat in terms of the EIA regulations since then, because what the EIA regulations now require is for, if somebody comes forward with an AMC application for something that has not been assessed, so in other words, if we proposed a tower block where it had not been assessed before, the council is perfectly entitled to rescreen that, consider whether it would have significant environmental effects, and if so, demand a further environmental statement. So I can give some further consideration to it, but my initial reaction is I don't think we'd need some sort of 3D parameters within the condition itself.
Okay, I've noted those comments. Now, Mr. Houghton, who I don't think is here, but he considers that condition 2A should require a planted buffer to mitigate the impacts on Milburn Tower, and he refers me to HES's response of the 20th of October 2015. Any comments from the applicant and the council on that?
Sir, we're just discussing with Ms McGrath there. My understanding is that there's perhaps been a misunderstanding by Mr Houghton as to what HES were actually requiring. There was a further discussion, I gather, with HES, and there is a document, I think, which has been lodged that explains what HES's current position is. Now, M28, I'm told. So this letter of 12th November, oh no, sorry, beg your pardon, if we go right back up to the beginning. So the exchange of emails is Catherine Middleton from HES confirming to Steve Nelson from Gillespie's that what's attached summarises their discussion and sets out the basis on which HES consider the application. And then the letter itself talks about the buffer screen, and you'll see that in the letter, Steve Nelson explained that there is a buffer zone of planting proposed along the western boundary of the development shown in the submitted plans, which varies in width between 10 metres and 25 metres. The intention of this planting is to help screen lower levels beneath the existing tree canopy, etc., etc. And there was a second recommendation as well, which may not actually be relevant to this point. I think in short, and I'm just getting Ms McGrath to confirm this, but what is set out in the Gillespie's letter has been agreed now by HES and does not require the 40-metre buffer that Mr Houghton suggests is required. Yeah. So
in other words, a buffer between 10 and 25 metres in width rather than 40. And how would that be controlled by condition? Which condition would it fall under?
I think if you look at condition 4, which has got a fairly extensive list of matters that need to be approved, there's again a fairly extensive section on landscaping itself, so detailed soft and hard landscaping, schedule of all plants, landscape management plan, any boundary treatments. So I would suggest that that would all be covered as part of the approval of matters set out in condition 4.
Those requirements are, well, look to be by and large pretty generic. Wouldn't there be a case for having a specific clause within that condition requiring this planted buffer given the impacts on Milburn?
think there are two ways of going about it. You either leave it to this more general policy. In designing the development through AMC applications, clearly there'll be a number of issues that are raised and addressed by way of landscape impact. I would rather have flexibility in the way that that was implemented, and it can be, no doubt, be addressed by both Historic Environment Scotland and the Council. So if you felt there was a need for very specific condition relating particularly to that, then I don't suppose we'd have objection to that. I would prefer flexibility.
Any comments from the Council on that? Would the Council, as a matter of course, be consulting HES on any subsequent detailed applications for this site?
Yes, sir. The situation as far as the AMCs are concerned depends obviously how the site is subdivided, and obviously there are parts of the site where we wouldn't necessarily expect HES to be consulted, but where they fall within the western boundary of the site, then yes. It might be appropriate at bullet point 5 under landscaping in condition 4, where it identifies any boundary treatments, including acoustic barriers and a means of planting along the appropriate parts of the western edge of the site.
Could you, between the applicant and the Council, look at how that clause could be made more specific given the concerns of HES there? So moving on, the applicant's comment on phasing site survey requirements in conditions 7, 11 and 15, and that would be to tweak the conditions that the Council proposes to have those site surveys carried out sequentially or in the order that the individual sites or plots are taken up. Any comments on the reasonableness of that from the Council's point of view?
So the only one of those conditions that I might be concerned about would be condition 15, which is one of a number of conditions as set out by Edinburgh Airports in terms of the operation function of the Edinburgh Airport and surrounding areas, where they've set out specific conditions. We tend not to alter, manipulate or change any of those, but it may well be that the Edinburgh Airports would be happy for that to be incorporated, but they haven't been asked at this time.
I understand your caution on that. It would be strange though, wouldn't it, for detailed landscape plans to be submitted at the outset for every phase of development?
Yes, I would agree with that.
I wonder if in the further discussions that you'll be having, whether it's possible just to check with the airport as to whether they'd be happy with that condition being phased. But as far as conditions 7 and 11, you were content with the applicant's suggestion that that be phased? Yeah. My next question relates to condition 18, where the applicant doesn't consider that condition to be necessary as the topic of air quality impact was assessed as part of the ES and no objection was raised. So I guess my question is, wouldn't condition 18 is drafted, just require a second assessment of something that already has been assessed, or is it not that straightforward?
Yes, sorry, I'm trying to find my way around the papers. The matter of air quality was considered as part of the environmental statement, and in reaching its conclusions, the environmental statement says that, subject to mitigation measures, this should be acceptable. But there are no details in the environment statement of what those mitigation measures would be, and as a point of issue raised by the Council's Environmental Health Officer, that there was concern in terms of air quality, particularly where the site borders the Edinburgh City bypass and the AA8, that might be something that needs to be looked at further in the absence of any proposed mitigation.
So your understanding is that there wasn't a completely clean bill of health arising from that assessment, that further work needs to be done, but presumably no indication that in principle there might be a significant issue there?
No, sir. The environment statement says that the matters can be sorted out and mitigated correctly. It's just in the absence of knowing what those would be, the reason for the condition, hence it being condition 18, not condition 2.
Mr. Holder, might it be just the problem is with the wording of the condition, which sort of indicates to me that work needs to be done from scratch rather than further information and details of mitigation being required? Sure. Yep.
Yeah, there is within Technical Appendix 8. There is in fact mitigation proposed, and that is set out at section 8.7 of the Technical Appendix. Now, I think the best that I can do at this stage is to suggest that we have a further discussion with the Council. It may be necessary to get the air quality people speaking to one another just to see whether there is a misunderstanding as to what information was before the Council and what is now required, because there is reference to mitigation set out within this. But I'm afraid I'm not in a position to tell you much more about that at this stage. So could I suggest that this just forms part of it's something that we will get back to you on, and hopefully we'll be able to come up with a form of condition, perhaps along the lines that you've recommended, or suggested I should say there, which requires anything additional rather than going back to square one.
Sounds reasonable. Council happy with that?
Yes, we are happy with that approach.
Okay, good. Okay, those were all of the questions I had on the detail of conditions. No other points from anyone else? Nope. Okay, in that case, yep, if the applicants and the council can discuss the points that have been raised this afternoon with a view to agreeing further iteration of that draft schedule of conditions and submit it to me when that is ready. If agreement can't be reached on all of those changes, you just make it clear in one way or another where that has been the case and the reason for that. Okay, so moving on to item 4, which is the proposed planning obligations. So the Council's hearing statement expands on the heads of terms set out in the Council's earlier informatives. Those arose from the Council's consideration of the proposal. So just a few detailed questions on those issues. And again, making it clear that I've split out any consideration of transport-related impacts from what we can discuss today. But the first one is on affordable housing, and I'm not exactly clear what heads of term, what any heads of terms would be there. In other words, what would ministers require in the event of being minded to grant permission? So I'm looking principally at the Council's hearing statement and page 4 of that. So, in a nutshell, the Council's requirement in that obligation would be 25% of housing on the application site is provided as affordable housing.
Yes, sir. Given the size of the site, then we would look for on-site provision. Only for smaller sites would we be looking for off-site.
Okay.
So this will be wholly within the site.
And that's the applicant's understanding of that requirement?
It is, sir. Just actually noting one point that follows on from that, the Council's hearing statement says the legal agreement should, as part of the master plan requirement at condition 1, include details of their locations throughout the whole application site and provide the design standards to which they are to be built. That may go slightly too far at that stage, given the scale of the site, because one can imagine that whilst the location of the affordable housing units will undoubtedly be known at the time of the original master plan approval, the specific tenure for individual pods or the relevant design standards may not for some of the proposals a couple of years down the line. Now, we've been involved in negotiating many Section 75 agreements with the Council on large sites of this sort, and there is certainly a form of words that can be found that addresses both the Council's concern and a developer's concern. But if I well, maybe ask for the Council's views on that, but I would expect that we might need to tweak that second part just slightly.
Yes, I'm sure we'd be able to identify an appropriate form of words there. It's to meet the Council's design standards, so that we have affordable housing that meets a reasonable size of unit, and not too small in relationship to the remainder of the development of that part of the site.
Okay, so as part of your discussions on the revised schedule of conditions, you would include that particular, or the detailed wording of that obligation? Great. In relation to the other requirements to be covered by obligation, those principally related to, or those that we can talk about today anyway, related to education infrastructure and to primary healthcare infrastructure. Now, I'm clear on the wording that would need to be used, and I can't see any adverse comments from the applicant on that. So, unless anyone has any other issues, I'm happy that I know what I need to do with those. Okay? Mr. Wilson.
Just very briefly, sir, to pick up the point from earlier in the day about the denominational primary school.
Sorry, are you saying more?
Sorry, apologies. That the Council's original position on this application was that contributions would be needed for denominational primary schooling. As I understand it, the contributions now sought are working on assumption that no denominational school children would go anywhere other than the on-site primary school. And it's simply to flag that there's nothing in here to deal with what would happen if that assumption wasn't correct.
Well, my understanding of the evidence this morning was that the Council essentially proceeds at its own risk on that issue. If it's not requiring a particular obligation and it does transpire that it needs to accommodate children from this development at a denominational school, that's an issue for the Council as Education Authority. There's nothing specific proposed for this obligation on that matter as far as I can see.
No, there's nothing specific in terms of the breakdown for denominational and non-denominational. It's been appropriated into a single figure, and therefore, if it's necessary, could be utilised in that particular situation as set out by my colleague earlier on this morning.
Sir, I don't think certainly that's not what the agreed statement suggests. The agreed statement is saying that the primary school contributions are for an on-site, non-denominational primary school, just so there's no confusion on that point.
Mr. MacLeod.
Yes, I think that is correct. The discussions that had taken place with the Council recently suggested that it was, in the view of the education specialists within the Council, it was more likely that parents would choose to send their children to a new on-site school, regardless of denominational preferences, than to send their children to the existing schools. And my understanding of the evidence is as yours, sir. If that turns out not to be the case, that will be the Council's risk. The applicant will have, by that stage, built a school that is, I suppose, too large in essence for the number of pupils likely to be generated. But we're not talking about a significant number of pupils here.
Anything further that the Council wishes to say on that? Nope.
From West Craig's perspective, it would be helpful to know that the understanding of the applicants and yourselves, and my own understanding that denominational would be at risk to the Council if the assumption is wrong, is correct.
No, just to clarify then, if you'd like me to, sir, the Council's position on education requirements through planning obligations is set out in its hearing statement. So you'll see from there, they're not seeking contributions for denominational primary school in this particular application.
Presumably based on the assessment that education officials have made as to the likely destination of pupils from this development. And that's based on their experience of, I think, Queensferry was mentioned this morning.
That's correct. So that accords with the discussion this morning.
Okay. Okay. So moving on to agenda item 5, and that was arrangements for the future consideration of conditions and obligations arising from any further consideration of traffic impacts. My proposal is that the parties' positions on conditions and obligations related to transportation should just be rolled into their hearing statements for the hearing session still to be arranged on transport impact. Does everyone agree that's the most straightforward way to approach that? Yep. Okay. Good. Any other matters that we need to discuss on conditions and obligations? No. Okay. Thanks for that. So that closes the session on conditions and obligations. What we need to discuss now is arrangements for those elements of the examination that remain outstanding. So earlier we've discussed what we're likely to have to do in relation to additional evidence on SASA impacts and on transportation. So our aspiration is to look at some sort of sequential inquiry then hearing session, we think, at the minute in August, or that's what we're aiming for.
Although on reflection it's just a minor point, but it may be better to do it hearing first then inquiry, on the basis that Ms Wilson, I think, would be here for the hearing session anyway, and then all other parties could depart and we could have the more limited discussion on the limited SASA
I think
issues.
that makes sense.
Yeah.
Yeah. In terms of closing submissions, is there any merit in taking closing submissions on what we've heard this week, or would the preference of parties be to wait until we've concluded oral procedure on the case?
I think personally it would probably be better to wait until you've heard the evidence to see the closing submissions. I mean, we could give you partial submissions on a number of things and invite you to reach views on them. And I'm very happy to do that if you would find that useful. But it may be that you'd find it more useful to have submissions that cover the entire case.
I'm thinking from a practical point of view in terms of my availability to actually be working and writing this case up over the next 2 months. That's going to be limited due to working on other oral procedure and being on holiday, so there would be no real benefit to me to taking those closing submissions in now. And I guess not taking them in now leaves a bit of flexibility to tweak those depending on what happens in the oral procedure still to come.
Yes, sir.
Others happy with that? We put those to one side for now.
Yes, sir. I think submissions from ourselves would be fair. Yes, I think, just thinking about it there, it makes sense to do that as I see it.
Mr. Alexander.
Yes, I'm happy with that approach, certainly to wait after the transport session.
Okay. And presumably you're happy with that too?
Yeah, I think the only benefit would be my submission would be somewhat short at the moment.
Yeah.
Really very little to say.
You wouldn't have much to do this week? Yeah.
So
okay.
I'm quite happy with that.
Okay, so I think we're agreed it's sensible to delay submissions until the close of all oral procedure. And that leaves the issue of accompanied site inspections. My feeling was that I'd like to try to do the accompanied site inspection only for the SASA impact session, either tomorrow or in one of the two overrun days next week. I think despite the fact that I'm yet to hear, or likely yet to hear, concluding SASA evidence, I'd still like to do that whilst the evidence that we've had this week is fresh in my mind. Has there been any discussion with SASA on when they'd be available for that?
There has, sir. I had an exchange of emails with Mr. Ferguson earlier. Tomorrow's not suitable. It's looking like next Thursday, the 1st of June, and the suggestion is 3 p.m. for a meeting time.
And the itinerary was provided by SASA the other day?
It was. We had some suggestions as well as to places that you might want to go, but I'm not actually quite sure where that is. It may be sitting in my inbox actually, but if I perhaps check that and we'll email Ms Robertson and just give you an update on, I think the proposal is meet at SASA's HQ and then take it from there, but we'll give you an indication of where we think it would be useful for you to go and see well in advance of that.
Perfect. But so we'll hear more from the parties on that by email, but for now it's looking like 3 p.m. on the 1st of June. Good. Okay. Anything else that we need to discuss before closing? Mr. Alexander.
Just an update that the Council now have the updated modelling information, and that has been circulated to all parties this afternoon.
Perfect. Thanks for that. Anything else? No. Okay, well, in that case, thanks very much for your attendance today and earlier in the week. I'll see some of you perhaps next Thursday, and other than that, hopefully we'll be back for further procedure in August. Thanks very much, everyone.